Hello and welcome to Session 23 of the Basic Tax course. We're going to begin Session 23 with a review of the Session 22 quiz answer key. And let's begin with one of the most frequently missed questions, question number 2. Question number 2 kind of defies what seems logical, and that's why so many people miss it. The question says, quarterly estimated tax payments are generally due on, and intuitively, you would think every 3 months is the correct answer, so you would kind of gravitate to January 15, April 15, July 15, and October 15. But that's not the way it works at all. In fact, the first estimated tax due date is April 15th, which is 15 days after the end of the third month of the year. But then the next one is June 15, which is only 15 days after the end of the fifth month of the year. You then go to September 15th, which is another 3 months out, and then you have a 4-month break before the estimated tax payments are due again on January 15. So it's simply a matter of fact that you do need to remember that the dates are April 15, June 15, September 15, and January 15th, and are not necessarily logical. Question number 3, in order to claim a refund, a timely filed 2012 married filing separate return can be amended to married filing joint by what date? Now, one of the first things to remember when taking a look at this particular problem is the filing status change. We're switching from married filing separate to married filing joint. Is there a limit on how much time we have to do that? The answer is, well, yeah, typically within 3 years from the due date of the return, not including extensions. You're going to be allowed to do that. And usually you would do it to make a claim for a refund. But if you want to go the flip, which is to go and file originally as married filing joint and then amend and file married filing separate, there is a rule that says that can only be done prior to the due date of the return. So if you're trying to flip from married filing joint to married filing separate after the due date of the return, you cannot do it. And that's what we have, married filing joint to married filing separate after the due date. No. But this question is not about the no situation. It is about the yes, it is possible situation. And then when you're looking at the yes, it is possible situation, you're simply going to look typically to the statute of limitations for making a claim for a refund. And that would typically be 3 years from the due date of the return, not including extensions, which is why C is the correct answer. Next question in line, question number 8. When assembling a paper federal return for mailing to the IRS, you should do which of the following? Attach your Form W-2 to the front page of the return. Assemble the forms and schedules in any order that is convenient for you. Attach the forms and schedules behind Form 1040 in order of their attachment sequence number. Happens to be that D is the correct answer because both A and C are correct. There is an order to the forms. You should be aware that there is an order to the forms, and the order isn't necessarily the numerical number on the form. Rather, it is the sequence number shown in the upper left-hand corner of the form, and I'm going to gravitate over to the internet for you real quick and show you a few. So here I'm on the IRS website. I pulled up a Schedule A. I just randomly decided to select a form. And you can see here in the upper right-hand corner it says Attachment Sequence Number 7. Let's compare that with other forms that could be attached to the return, including Schedule C. And here you can see we have Schedule C, and the sequence order for Schedule C is number 9. Schedule A is number 7. Sequence number 9 comes after 7. That means when you're assembling the return, Schedule C would go behind Schedule A. And if I just randomly type a form, let's just select 2441. We can see that 2441 is sequence number 21. So it would follow behind both Schedule A and Schedule C. So whenever you're assembling a tax return, do look to the sequence numbers. Make sure that the forms are going in sequential order, because that's the way it's supposed to be done. So going back to the wording of the problem, D, both A and C are correct. I should also point out that as we sit currently, federal law requires paid tax preparers who work for a firm or who individually prepare more than 10 returns in a year to file all of those returns electronically. So for the most part, you're not really going to see yourself assembling tax forms in any particular order. But it isn't always possible to e-file, particularly if you're filing a back year return, say. So currently, if you want to file a 2012 return, as I sit here on October 29, 2013, recording this particular part of the course, I can tell you that the e-file for 2012 returns has ended. So today, if you try and file a 2012 return, the only way to send it in will be via paper. Also, if you file tax returns, amended returns, those have to go paper. And essentially any back year return have to go paper. So it is important to know the rules for how to assemble a return correctly. Number 9, if you fail to pay your federal income tax due by the due date, the penalty is which of the following? 1/2 of 1% of the unpaid tax for each month or part of a month, 1% of the unpaid taxes for each month or part of a month, or C, not more than 25% of the unpaid tax. Well, it happens to be that the rate for the penalty on unpaid tax not paid by the due date is 1/2 of 1% per month, but the maximum penalty cannot be more than 25% of the unpaid tax. Now, that's a very different concept than interest. Interest continues to accrue no matter what, but this is a question about penalty. It is not a question about interest. So that concludes this review of the Session 22 quiz. Let's get on with the Session 23 lecture. About a year ago, I came across this newspaper cartoon. It's Ziggy. Let me just make him fit on the screen here a little better. It was actually in one of the Saturday papers or the weekday papers in the funnies section. And a member of my staff here at Pacific Northwest Tax Service noticed this particular cartoon and brought it to me. And I thought, well, this is really a perfect cartoon to start off an ethics discussion. And let's just take a look at what's going on with our cartoon character, Ziggy. Obviously, he's at the IRS auditor's office. And the secretary is saying, sir, that little guy you're going to make an example of is here. Shall I send him in? And we look at it and kind of laugh for a number of reasons. One of them might be that poor Ziggy character, he's getting audited, and obviously he's got some pretty serious mistakes on his tax return in order for the secretary to be making that kind of comment. But the thing that was going through my mind when I read it is, okay, well, did Ziggy prepare his own return, or did Ziggy use a tax professional? And it's a good question, because obviously not all tax clients who get audited who did use a paid preparer are going to go to the audit with the paid preparer. As likely as not, they're probably going to march in there without their paid preparer. And in fact, I'm very often surprised at the number of my clients with whom I think I have very close relationships that inform me that they were audited by IRS, attended an IRS audit without me, and then they explain the results of those audits. And I'm going, you never asked me to consult with you on it. I was surprised by that. So it's entirely possible that even though Ziggy's there without his tax professional, that he did use one. And so if we look at the context of what that woman is saying, you're going to make an example of this Ziggy guy, and Ziggy did use a paid professional, that wouldn't necessarily be a good thing, because obviously Ziggy would have relied on his paid professional to do the tax return correctly, and now he's going to march into this auditor's office, and the auditor's going to throw a bunch of questions at him, and Ziggy's going to be powerless and helpless and not knowledgeable enough to answer probably most of them. And the reality is that in the world of tax preparation, only about 50% of taxpayers prepare their own returns, and actually a little more than 50% of taxpayers use a paid professional. So the odds that Ziggy used a paid professional are actually fairly high. And wouldn't it be great if every professional out there could prepare a tax return to such a level of accuracy that there was never a fear of the audit? Now, of course, even when we call ourselves extremely competent, we do make mistakes. And even when we do a perfect job on a tax return, an auditor can still challenge it. So there is always the side of the audit and how we're going to come out on top of it. And the purpose of today's lecture is twofold. One is the IRS requires that enrolled agents and possibly RTRPs, depending on how the outcome of the Loving case goes, are required to have 2 hours of ethics every year. So that's one purpose in teaching today's class, and that is that people are required to have ethics. But the other purpose in today's class is really to just make us sit back and think a little bit about our own practice as tax professionals and what we're doing to really excel at our profession. Because I'm personally of the opinion, as a tax service owner and as a tax preparer and as a tax school instructor, that our ability to deliver great service to our customers is totally dependent on the level of ethics that we practice. Now, one of the comments I've heard over time from people is, how do you teach ethics? You're either ethical or you're not ethical. And that's true. It's not hard to identify a person whom we consider to be unethical. And quite frankly, when I'm preparing tax returns for clients, I'm able to quickly ascertain whether or not I think they're very ethical people, how they answer my questions, how they react to the possibility of IRS questioning a particular deduction. One customer might be, oh my gosh, if there's any doubt at all, I want nothing to do with it. I don't want to ever have problems in an audit. And then you've got the other customer who is even pushing me when I tell them I can't do something. They're saying, well, I want to do it anyway, and I'm arguing with them about it. So we definitely get an impression of the ethics on our clients. And in working with other tax professionals, we may hear comments that they say and things that they do that may cause us to judge how ethical they are. But when we come to judge ourselves, most people think, I've learned this from statistical analysis, that most people think that they're ethical. And if they make decisions that other people deem to be unethical, they usually have their reasons for doing it, like their reasons give them an excuse for it. But when we're dealing with IRS ethics, there's more to it than just our opinion of what is an ethical person. There's actually understanding what law is. And under IRS ethics rules, we are required to know what the law is. And if we don't know what the law is, then actually we're in violation of ethics. So in taking today's class, we're learning how to be more ethical in our practice by adhering to the law, but we're also going to be discussing some of the things every good tax preparer should be employing in their business to ensure that they're delivering a quality service to their clients and avoiding the possibility of any IRS sanctions or penalties. Now, in compiling the information that is contained in today's class, I've read many different references, not the least of which, of course, is Treasury Department Circular 230. And when we think of IRS ethics rules, we tend to, at least we should, be thinking of Treasury Department Circular 230. But there are a number of other publications and pieces of tax code that should be referenced, and I've included a list of these here in the manual. Some of these are potentially outdated because we don't know what the outcome of the Loving case is. So many of these references that I'm including in here have to do with the Registered Tax Return Preparer program, and as long as that's in limbo, we don't really know how current or relevant these are, but the information is still contained in here if you would like to go reference it. And with that, let's get on with the overview. The tax preparation industry is comprised of a wide range of individuals and groups who assist taxpayers with preparation of tax returns, filing of tax returns, and IRS representation. These individuals and groups can include certified public accountants, attorneys, enrolled agents, enrolled actuaries, enrolled retirement plan agents, registered tax return preparers, and other unenrolled tax preparers who charge a fee for preparation services, unenrolled tax preparers who prepare tax returns for free, software developers, and government employees. The IRS historically has not regulated the preparation industry outside of authorizing and regulating preparers who fall under the provisions of the Treasury Department Circular 230. In previous versions of Circular 230, the IRS placed tax preparers into two distinct categories: preparers who are granted the authority to practice before the IRS, and preparers who do not have the authority to practice before the IRS. That was it, just those two categories. And historically, the scope of Circular 230 governed the recognition of attorneys, CPAs, enrolled agents, and other persons representing taxpayers before the IRS. The IRS has now expanded the scope of Circular 230 to a newly created category of tax preparer called a registered tax return preparer. In addition to the following regulations described in Circular 230, practitioners should be familiar with the provisions of IRS Publication 470, which has to do with limited practice without enrollment, IRC 6107, which is regulations or laws requiring the tax preparer to furnish a copy of a tax return to the taxpayer and then retaining a copy or list. Also, IRC Section 6109 relating to identifying numbers, 6694, which is with understatement of taxpayer's liability by a tax return preparer, what happens when that happens. Section 6695, other assessable penalties with respect to the preparation of income tax returns for other persons. Section 6701, penalties for aiding and abetting, the understatement of tax liability. IRC Section 7216, disclosure or use of information by preparers of returns. IRC Section 7525, confidentiality privileges relating to taxpayer communications. Also, Internal Revenue Bulletin 2009-3, tax return preparer penalties under Section 6694 and 6695, and Internal Revenue Bulletin 2010-46, furnishing the identifying number of a tax return preparer. So we're going to talk about most of this stuff in today's class. How much time we're able to devote to each topic is really going to depend on how quickly I get through things, and this is a big course with a lot of pages to squeeze into 4 hours, so there's probably quite a bit of it we're going to jump through rather quickly, and other parts I'm going to focus in on because I feel they're more important. And I like to have a historical introduction to topics like this one, just to kind of place us in time and how we got to the point we are now with the IRS appealing a case in federal court in the month of September. Why is it that we're here? How did that come to be? Obviously, there's lots of opinions, some of them fairly strong, some of them blasé, I don't much care. But historically, most tax professionals have been subjected to little or no government oversight. With the exception of tax preparers in the state of Oregon and California, anyone could offer his or her services as a tax professional, regardless of training, education, experience, or background. I personally think it's a little bit shocking that a person can put up a shingle in any state in this nation outside of California and Oregon and offer their services as a tax professional, even if they have absolutely zero training in tax law. And of course, that has created some problems. There's been a lot of discussion and a lot of complaint over it. The news media loves to run stories about how inaccurate tax returns are and corrupt tax services. They're on the news regularly. And so the General Accounting Office was commissioned by the Senate Finance Committee to do a study. And it published that study in August of 2008. And the result of its study was called Tax Preparers, Oregon's Regulatory Regime May Lead to Improved Federal Tax Return Accuracy and Provides a Possible Model for National Regulation. Now, if you come from Oregon, which I do, we're a little bit proud of our situation here because we are a role model for the IRS and the rest of the nation in terms of how you can have a tax preparer regime in place that is regulated and does improve accuracy. And this GAO report really confirmed what Oregonians have known for a long time, which is that regulation can have some positive benefits. And the summary that was provided in this report is this. Why did GAO do the study? Millions of taxpayers use paid tax return preparers, and many of these paid preparers are not subject to any qualification requirements. Paid preparers in California and Oregon are exceptions in that these states have set paid preparer qualification standards. To help Congress better understand potential costs and revenue effects of regulating paid preparers, the GAO was asked to study how the IRS, California, Oregon, and other states regulate paid preparers, how the accuracy of federal tax returns from California and Oregon prepare to other returns, and state-level costs and benefits of the California and Oregon programs and insights they provide for possible national program. The GAO analyzed IRS research data on tax return accuracy, interviewed IRS officials, state administrators, and the preparer community representatives, and reviewed relevant documents. According to the GAO analysis of the IRS's tax year 2001 data, Oregon returns were more likely to be accurate, while California returns were less likely to be accurate when compared with the rest of the country. After controlling for other factors that were likely to affect accuracy, in dollar terms, the average Oregon return, and we're talking a decade ago now, 12 years ago in fact, 2001, the average Oregon return required approximately $250 less of a change in a tax liability than the average return for the rest of the country. For Oregon's 1.56 million individual tax filers, that equates to over $390 million more in federal revenue that was paid by Oregon taxpayers than would have been paid by Oregon tax preparers if they were as accurate as the rest of the country. So I look at this and say, okay, Oregonians paid $390 million more in tax than other people in the rest of the country would have been paying on equal terms. So because Oregon tax returns are more accurate, the state gets to pay more than its fair share, you could say. Or you could say that the amount of revenue being brought in federal tax dollars is grossly low, and that perhaps better oversight and better training of tax preparers is going to improve the amount of revenue coming into our government without having the need for as much tax increase. This is kind of my perspective or take on it. At any rate, as an Oregonian and as a taxpayer, I'm going, wow, we're paying that much more because that's significant. We're a little tiny state with a little population. So what happened as a result of that? Well, as a result of that study, there were bills submitted to the Senate, there were bills submitted to Congress, and they all died on the floor. They never really went anywhere in terms of promoting national regulation of tax preparers. But on the side of it all, the IRS was taking a look at regulation already in place and deciding, maybe we can use some of the existing laws in place to implement a program of our own. And so that's why I have a header here that says the IRS takes charge. In 2009, the IRS launched a review of the oversight of federal tax return preparers. It held open meetings with constituent groups and received written comments in response to a request for input on standards from the tax return preparer community. They allowed people to come to open forums, and they also allowed people to submit their comments in writing. And perhaps some of you in attendance today even did that, submitted a comment in writing. A lot of people did, and I certainly had an opinion, and so I submitted it at that time as well. On January 4, 2010, the IRS published a report proposing new registration, testing, and continuing education of paid return preparers. And when that report first came out, a lot of people were saying, well, this is just proposed changes. They're not really going to do anything. And then to everyone's shock, the report was really not just a proposal of changes, it really was changes. And they were basically not saying that they were proposing changes, but rather that they were going to make changes, and how those changes would finally eventuate was what was really up in the air. They were going to do something and they were going to implement it pretty quick. And it was pretty amazing how fast it all came together. So the IRS began enforcing the new standards in late 2010 with the introduction of the online PTIN system. Then in December of 2011, the RTRP test was launched, and for 2012, continuing education requirements were mandated. The PTIN requirement is the big one that first got it all going, and under that, all paid tax return preparers are required to register with the IRS, pay a registration fee, and obtain a preparer tax ID number. Tax preparers who already had a PTIN prior to 2010 were required to apply and re-register their existing PTIN. So I believe I got my PTIN way back in the mid-1990s when they first came out. And back in the mid-90s when PTINs were first authorized, or the IRS first started to allow preparers to get PTINs, the main concern was that the preparer did not want his or her own Social Security number being used on tax returns that would then be available to people to use for identity theft purposes. So the original PTIN, in terms of the tax preparer, was a way of protecting the Social Security number. But the IRS then decided or determined that it was going to use the PTIN system in a whole new way. Now, as we know, there was a big thing that happened in 2013, and that is on January 18, the U.S. District Court enjoined the IRS from enforcing many of its regulations. And in accordance with this order, tax return preparers covered by this program are currently not required to complete competency testing or secure continuing education. The enjoinment resulted from the case called Loving versus IRS, in which U.S. District Court Judge James E. Boasberg ruled in favor of 3 tax preparers, Sabina Loving out of Chicago, John Gambino out of New Jersey, and Elmer Killian of Wisconsin. Judge Boasberg found the IRS had exceeded its statutory authority in imposing its registered tax return preparer requirements. It was foreseeable that the IRS would appeal, and it has appealed. The oral arguments relating to the IRS appeal of the Loving case are scheduled to begin on September 24 at the Federal Appeals Court in Washington, D.C. Now, the PTIN requirements do remain in effect, so although the IRS has been enjoined from enforcing some of the tax preparer regulations, it has not been enjoined from enforcing all of them. At this point, it's not allowed to enforce testing or education requirements on unenrolled tax practitioners. It is only allowed at this point to enforce the PTIN requirements. So the ruling does not affect the regulatory practice requirements for CPAs, attorneys, enrolled agents, enrolled retirement plan agents, or enrolled actuaries. And on Friday, February 1st, the court did modify its order to clarify that the order does not affect the requirement that all paid return preparers obtain a PTIN. So what happened was on January 18, the IRS was enjoined from enforcing its regulations, and so it shut down everything. It shut down the testing, it shut down the PTIN system, it shut down all of it. And then after the 1st of February, the IRS was given permission, or it was explained in greater clarity, that the PTIN system was allowed to continue, and so the IRS did reopen it. So what's been happening in the interim? I'm just curious, has anyone in attendance today had an opinion that they've expressed to any government official in their area? Have you all been kind of silent and just talking amongst yourselves, or have you had an opinion that you've expressed politically in any way to a representative? Doesn't hurt to be a little bit vocal in this industry. After all, I think as tax practitioners, if we have an opinion and we wish to express it either directly in person or through our company or through an association we belong to, we can have some effect on how our government proceeds with things. And so certainly locally here in Oregon, I have been in contact with my own congressman's office saying, hey, here's my opinion. I've talked with members of my congressman's office on it, and they've been genuinely interested in hearing what I had to say. And it appears that there's a number of politicians around the country who are interested in what's going on with this. And certainly at this point, if you have any input into what you would like to see done, whether it's in support of or in rejection of the IRS regulations, you certainly have an opportunity to say something right now, because here's what's going on. Members of both the U.S. House of Representatives and the Senate are awaiting the outcome of the IRS's appeal of the Loving case later this year. The Senate Finance Committee's working paper on simplifying the tax system for family and businesses states that regulation of tax preparers. Due to tax law complexity, taxpayers increasingly rely on third parties to prepare their tax return, thereby increasing their exposure to preparer misconduct or error. In 2011, the IRS started regulating tax return preparers by requiring registration and imposing minimum competency standards. The District Court of Washington, D.C. recently ruled that the IRS lacks the authority to regulate tax return preparers. If the IRS does not prevail in its appeal of the Loving case, it will lose an important tool to increase tax compliance and protect taxpayers from unethical tax return preparers. The Finance Committee proposes to ensure that the IRS has the authority to oversee paid preparers by providing clear statutory authority for the IRS to regulate tax return preparers if the IRS loses the appeal of the Loving case. So that's the Senate's position, or at least people in positions in the Senate have made this case. Separate from that, we have H.R. 1570, which is the Taxpayer Protection and Preparer Fraud Prevention Act of 2013. Now, I did say earlier that other bills have been submitted to the House and the Senate, and they have died on the floor in the past. But now we're perhaps in a little bit different time, and depending on what happens with the Loving appeal, we may actually see movement this time around. This particular bill was introduced to the House of Representatives on April 15, 2013, and if enacted, H.R. 1570 would give the IRS the authority to regulate tax preparers in a manner similar to what the IRS was already enforcing prior to the enjoinment. I have gone in, and if you click on the link in the manual, it will take you to the act and you can read it. And it's very short. It's only 3-4 pages long. And in a nutshell, it essentially says that the IRS shall have the authority to regulate tax preparers in exactly the way the IRS has already decided that it does. And so in its simplest form, if there's no further debate on the issue, this would cement it into law regardless of the outcome of the appeal. But of course, any kind of law like this is going to take a certain amount of time to pass. And if the IRS prevails on appeal, things will be cemented, I think, pretty quickly. And if the IRS does not prevail on an appeal, then it may be more long and drawn out. But I do see eventually, regardless of the outcome of the case, that we will have regulations governing tax preparers, whether it's in 2013 or 2015. I don't see it as being that far along. So let's move on again and take a look at a couple of requirements. And one of those is the RTRP competency test and continuing education requirements. Of course, these are currently suspended. We've had a number of comments from people who have taken our ethics class prior to today because we hadn't updated it, saying, well, can't you update the class? Can't you change it in some way to accommodate the new rules? And the reality is, at this point, there are no new rules. What's happened is the IRS cannot enforce the rules that it has. And until it has either given the ability to enforce the rules it has, or it is clearly made apparent that it can't enforce those rules, there's nothing much to teach other than that the rules exist and that currently some of those rules cannot be enforced by the IRS. And of course, key among those are the RTRP examination and the continuing education requirements for RTRPs. But other than those two specific aspects, the regulations are not that much changed at all. Now, many people are wondering what's going on. The IRS Return Preparer Office of the IRS has a Facebook page. I don't know if any of you have ever been on it, but it's really the best place to go to get the most updated information. And when you go there looking for something updated, it isn't updated very often. The most recent update that was placed on that page was dated May 17, and it was posting by Carol A. Campbell, who is the director of the IRS Return Preparer Office, and these are her words. It has been a little while since I've had the opportunity to engage with you, but I thank you for your patience and support as we continue to determine the appropriate actions and next steps while we await the outcome of the appeal of the Loving case. We remain confident in our legal authority to regulate paid return preparers and committed to protecting taxpayers and tax administration by implementing reasonable standards for tax preparation. In the interim, we must ensure that all the actions we take are consistent with the existing court order. I know many of you have questions and opinions about what we can do, and actually that's true. If you go to the RPO Facebook page, you can read opinions till you're exhausted. Everybody has an opinion, and many people with opinions are posting them on that Facebook page. Some of them are sympathetic and saying, yeah, we understand why it is you can't do these things. Some of them are complaining about why isn't there more clarity. Other people are going, ha ha, we knew it was all illegal and the IRS can't be regulating in this way. You deserve these problems. There's all different kinds of opinions on that page. And what Carol is saying is that she knows that many people have questions and have opinions about what we can do and what we should do and what the court order allows and does not allow. As I've been following the discussions that are posted on the page, that's what she's saying. I have found much of the discourse to be thoughtful, enlightening, and generally very encouraging on a number of fronts. There will continue to be questions that remain without answers while the litigation is pending, because we have to give the legal process the respect and deference to which it is entitled. In some instances, it may be that we are exercising an abundance of caution. In others, it is because reasonable minds could and have disagreed as to what the correct answer is given the court's order, and there is still another category where the language of the order itself is not the issue, but it is the lack of compatibility between that order and the administrative processes we put in place to stand up to the Return Preparer program. What she's saying in that, and what I'm interpreting as what she's saying in that, is a number of people have been concerned, well, I already took the RTRP test. I've got my RTRP credential. Is that worthless now? And the IRS is actually silent on that issue. It's not saying what it's going to do with the RTRP program. It's completely silent, and I believe that's what she's expressing here, that people are frustrated over the effort they've put forth into getting their RTRP credential, and now the IRS is not saying whether it's valid or invalid or anything. It's just completely silent on the issue. And the IRS is just playing it safe, and it's believing that saying nothing is better than saying something and get caught saying the wrong thing. That's actually an expression my husband has. He reviews all of the tax returns in our company, and when a tax client calls with a question about the status of their tax return or a position taken on their tax return, he says no information is better than bad information. Say nothing at all to that client about the return in any way until you know for certain that you have the fact in front of you and that it is accurate. For example, if the client calls and wants to know if their tax return is ready for pickup, you go to the drawer, you open it, you identify it, you see that it's in there, and then you come back to the phone and say, yes, it's ready. And anything less than that is leaving the door open to problems. And that's a very simplistic example, but the IRS obviously has a much more complex situation in that it can't say what it maybe would like to say just because it doesn't want to give out any information that in the end could be proven wrong. Now, Carol does go on to say that for some of you, this response is not palatable, and I understand your frustration, but irrespective of where you stand on preparer regulation, we have to allow the process to work as it is intended. And consistent with that process, we will soon begin refunding fees collected for registered tax return preparer tests, appointments canceled due to the injunction. Additionally, we will also refund fees collected from return preparers who tested on or after January 18 before we were able to officially stop the administration of the test, because this testing was scheduled and taken as a requirement of the Registered Tax Return Preparer Program and thus was in violation of the court order. For those of you who qualify for a refund, no action is necessary. A credit for the test fee will automatically be made to the account used to pay the fee. So most people would have used a credit card, and the credit card will be reverse charged. For more information, see the Frequently Asked Questions section and our updated statement. Thanks for your patience. The IRS has also issued another official statement that you can find on its website. It was last updated the day before Carol made her statement. And it says, fee amounts collected for scheduled registered tax return preparer test appointments canceled due to the court-ordered injunction are being refunded. Additionally, fees collected from return preparers who tested on or after the 18th of January, the date that the test was enjoined, are also being refunded. No additional refund or reimbursement
requests related to the registered tax return preparer regulation are being provided or considered at this time. So a lot of people are saying, well, I already took the RTRP test. I got my RTRP credential before that date. Don't I get my money back? And the answer is no. The IRS is not considering refunding anybody other than people who took the test or paid the fee on or after the 18th of January. And it goes on further to say that no action is necessary to receive the refund. It's going to be happening automatically, and it is anticipated that these fees will be fully refunded by the 19th of July this month. So here is a summary of the current tax return preparer requirements. You won't find this summary on the IRS website anymore. It was posted on the IRS website until January 18th, and then poof, it was gone. But I'm teaching the law as it currently exists. And if there is a change to the law, then when I teach an update to this class, probably in October or November after we have more certainty, I'll adjust it as necessary. But as we're sitting right now, there is a PTIN requirement in place for all categories of tax preparers. Every preparer who prepares a tax form is essentially required to have a PTIN. That has not gone away. And in the effort or part of the procedures for obtaining a PTIN, all the applicants for PTINs do still continue to need to pass that compliance check. I haven't seen any tax compliance check changes in that regard. The PTIN system is existing and continuing as it was before. The background check was an idea that the IRS originally proposed in its tax preparer regulations, that it was going to require all tax preparers to go through a background check that included fingerprinting. And there was a lot of pushback on that other systems might be available that could do just as good a job, that were less intrusive or less expensive. And so the IRS basically set that on the back burner. And as we're sitting at this time, of course, it's way, way, way on the back burner. The IRS test, currently enrolled agents do need to sit the test. And under the regulations, tax preparers need to sit the test unless they're CPAs or attorneys. However, currently that is not enforceable. Enrolled agents do have to complete 72 hours of continuing education every 3 years, and that rule is not affected. But of course, tax preparers who are not enrolled agents or CPAs or attorneys need to complete 15 hours every year, and that particular rule is under enjoyment and is not enforceable at this time. Now, the practice rights column here, this is unaffected. Enrolled agents currently have unlimited practice rights, and whether you're an unenrolled preparer or whether you passed the registered tax return preparer test and received your card, either way, your ability to practice before the IRS was limited and remains limited. CPAs have unlimited practice rights, as do attorneys. And then there's this category called supervised return preparers and non-1040 preparers. Those two categories still exist, and when you submit an application for a PTIN, if you fall into one of these categories, you would select it. All right, so we have the Return Preparer Office Federal Tax Return Preparer Statistics. I've got statistics that I pulled off the IRS website in April of 2012. And these statistics showed the number of individuals a year ago who had PTINs. 710,000 people had PTINs a year ago. And of those, 30,000 were attorneys, 211,000 were CPAs, 533 were enrolled actuaries, 42,768 were enrolled agents, 525 were enrolled retirement plan agents, and 2,712 were registered tax return preparers. Obviously, this is a pretty early statistic, and between the time this statistic was released in the end of 2012, a lot more people would have taken that test and passed it. And I don't have the statistic with me now on how many people did obtain the credential before that information was pulled off the IRS site. But then we'll see other categories. We have the supervised tax return preparer category, 54,000, and the non-1040 preparer category of 41,000. And then we had preparers who had obtained provisional PTINs who had not yet passed the RTRP test, and that was the largest category of all. Now, if you go to the IRS website and look for that same information, we can see that the number of PTIN holders has dropped significantly. It's dropped by 30,000 or more. 678,000 people now hold PTINs, and of those, 31,000 are attorneys, 212,000 are CPAs. So the number of attorneys and CPAs with PTINs has risen. The number of enrolled actuaries has dropped, and the number of enrolled retirement plan agents has gone up. And interestingly, the number of enrolled agents has also gone up. I think that's a pretty big jump statistically to go from 42,000 EAs to 46,000 EAs in the space of a year. It seems a number of people have made that a priority. And then the supervised tax return preparer and the non-1040 preparer categories have also jumped significantly. But if you add up all of these categories here, you can see we're missing the registered tax return preparer category, and we're missing the preparers with provisional PTINs who've not yet passed the test. They're not even publishing those numbers anymore. So we can only speculate at what they are at this point in time. So let's move on with a discussion of the tax preparer registration requirement, because that requirement is unchanged. It is only the testing and education requirements that have changed or that are under enjoyment right now. The criteria for obtaining a PTIN are unchanged. So we're going to go through the regulations affecting that, and they fall under Section 6109. IRC 6109 authorizes the Secretary to prescribe regulations for the inclusion of identifying numbers on a return, statement, or other document required to be filed with the IRS. The IRS has utilized the provisions of 6109 to control tax preparer registration and compliance. Under the section, the IRS has the ability to require use of an identifying number by a paid preparer and require that the identifying number be one that is issued by the IRS, and also to set forth rules under which an identifying number will be issued and renewed. And so if we're thinking a little bit about the Loving case and what it is that the IRS is appealing on, I think it's this point number 3 right here. It's not being disputed that the IRS can require tax preparers to have a number and that the number be issued by the IRS, or even that the IRS can charge for that number, which it is doing, but rather whether the IRS can say that in order to get a number you have to pass a test and that you have to get CPE. The rules are simply that the IRS can make the rules according to what I'm reading here, and the court is saying, well, you can't make the rules that go that far. And so we'll see where the appeal goes and whether it's determined that the IRS can make rules that go that far. In 2010, the IRS published final regulations addressing tax return preparer PTIN requirements and final regulations regarding the user fee that you need to pay in order to apply for or renew a PTIN. And effective January 1, 2011, all CPAs, attorneys, enrolled agents, and unenrolled tax preparers who prepare tax returns for compensation are required to be registered with the IRS. The IRS considers the preparation of a tax return for compensation to be a form of representation before the agency. Thus, the IRS has amended the regulations in 31 U.S.C. 230 to specify that any person preparing a tax return for compensation is practicing before the agency and therefore must demonstrate good character, good reputation, necessary qualifications to enable the representative to provide valuable services, and competency to advise and assist persons in presenting their cases. Now, I should point out that one of the arguments made in the Loving case is that preparation of a tax return is not presentation of a case. The IRS is saying that preparation of a return is the presentation of a case. Quite frankly, I agree with the IRS. When I have a client come and sit down with me and they bring me tax documents or bring me their personal information that I interpret and put on a tax return, I think I am very much making a case. I'm establishing whether or not they're entitled to a deduction under the law, how much that deduction should be that they're allowed to claim, and I'm evaluating what documents they have that support that. I think it is very much the argument for a case. However, the court felt otherwise. So again, we'll see who prevails on that issue. So who is covered by the PTIN registration requirement? Well, everybody, including CPAs and enrolled agents and attorneys. They're all required to have a PTIN before they can prepare any federal tax return for 2011 or later years. Amendments to rules under Section 6109 addressing the preparer tax identification number were finalized on September 30, 2010. And the section was amended to read furnishing identifying number of tax return preparer. The new regulations state that after 2010, the identifying number of a tax return preparer for returns or claims for refund filed is the individual's PTIN or other number prescribed by the IRS. All tax return preparers must have a preparer tax ID number or other prescribed identifying number that was applied for and received at the time and in the manner, including the payment of a user fee, as may be prescribed by the IRS in forms and other guidance. To obtain a PTIN or other prescribed identifying number, a tax return preparer must either be an attorney, CPA, enrolled agent, or a registered tax return preparer. A specified individual who is supervised by an attorney, CPA, enrolled agent, enrolled retirement plan agent, or enrolled actuary who signs the return or claim for refund prepared by the individual, or an individual who certifies that he or she does not prepare or assist in the preparation of all or substantially all of any tax return or claim for refund covered by the competency examination, which is the 1040 form series, and accompanying schedules until further notice. And you notice here I have a little asterisk next to this RTRP category. Currently, the IRS is enjoined from enforcing the rule that only a registered tax return preparer can have a PTIN, and so pretty much anyone can apply for a PTIN at this point in time and get one. But once we have the outcome of the case, we'll know where that's going to go. Now, it is possible to prepare certain forms for compensation without having a PTIN, and on the IRS website you can find a list of what those forms are. I have them listed here, and you will see that pretty much you're not looking at forms that are any part of the 1040, 1065, 1120 series, 1041 series. These are forms that really have to do with payroll or application for identification numbers, powers of attorney. There's one here for a change in accounting method. Those types of forms you can be paid to prepare without a PTIN. They also have the retirement plan forms. If you're filing a tax return for retirement plan 5500 series, you don't need a PTIN for that. But other than that, if you're preparing a tax form that is going to be part of a tax return, whether it's individual or otherwise, you do need to have a PTIN. Now, there is a category that the IRS has had for PTINs called provisional PTINs, and they've had this provisional PTIN category specifically because the rule states that only an RTRP or one of the other authorized groups, including CPAs, attorneys, and enrolled agents, is eligible for a PTIN. So how is it that people who are not one of those categories have been getting PTINs? Well, the answer is the IRS has been issuing them provisional PTINs. And if you apply for a PTIN and you are an enrolled agent, CPA, or an attorney, you get a PTIN. And it says you've got your PTIN. But if you belong to the unenrolled category of tax return preparer, who is not a supervised return preparer, then you are issued a provisional PTIN. So what is that about? Well, the IRS originally stated that it would issue provisional PTINs to individuals who are not attorneys, CPAs, enrolled agents, enrolled retirement plan agents, or enrolled actuaries, and that individuals who receive provisional PTINs must meet testing and or suitability requirements before a permanent or active PTIN can be issued to them. Initially, the IRS planned to cease issuing provisional PTINs when the registered tax return preparer competency test began, and to require individuals to pass that test and meet all other requirements before issuance of a PTIN. Later, in another notice, 2011-80, the IRS stated that the provisional PTINs would continue to be issued until at least April 18, 2012. And then afterwards, it said it would continue issuing them past 2012 and would determine the future of the provisional PTIN program by December 31, 2013. And of course, now the entire thing is in hiatus again, pending the appeal of the Loving case. So at this point, the IRS is continuing to issue provisional PTINs until such time as other decisions can be made regarding it. Now let's talk about the compliance check. As a part of the registration process, tax return preparers are also subject to a tax compliance check, which includes a review of the preparer's history of compliance with personal and business tax filing and payment obligations. The IRS compliance check will examine the following facts. Did the preparer file a tax return if he or she was required to do so? Is the preparer current on tax payment obligations? If a preparer has been audited, did he or she pay the additional taxes owed or enter into an installment agreement? A preparer who has entered into an installment agreement and is current with the agreement is deemed to be in compliance. The IRS will be auditing tax preparer returns as a part of the preparer registration program, and compliance check measures are directed at whether the preparer is current with tax filings and payments. So if you are applying to become an enrolled agent, the IRS does take a close look at your tax returns. It looks at the numbers that appear on them and thinks about them and decides whether the tax return looks clean on the face of it. I know that most people I talk to who pass the enrolled agent exam, that's one of the things they're concerned about, is whether or not they're going to get called out for a full-blown audit and whether IRS has any opinions about their own tax returns. When it comes to the issuance of a PTIN, the IRS is definitely not looking that closely at that particular issue. It's really looking to see, were tax returns filed? If the tax preparer owed tax, was the tax paid? And if the tax was not paid, has that practitioner entered into an installment agreement, and is that practitioner current with the terms of that installment agreement? If there is a yes to any of those, then the tax preparer is considered to be in tax compliance. Renewal period. PTINs must be renewed annually, with the annual renewal period running mid-October through December 31, and renewals for 2013 must be completed between October 15, our estimated projected time frame, and December 31, 2012. And obviously for the 2014 season coming up, we're expecting that the renewal period will begin in mid-October and go through the end of December. So what this means is that if you head into the 2014 season, you need to have renewed your PTIN prior to the beginning of that season in the last quarter of 2013. PTIN registration and renewal procedures. The IRS recommends that tax preparers apply for or renew their PTIN and pay the application or renewal fee online. The application fee for an initial PTIN is $64.25, and if you wish to renew your existing PTIN, you have a bargain rate of $63. If you are a paid preparer, you may not use your Social Security number in lieu of your PTIN on returns that you are paid to prepare. Do not write PTIN applied for in the section of a tax return that is only for the paid preparer's use. To apply for a PTIN online, go to the URL that you see here. When you land on the page, this is what you'll see. It has a video on what to do if you are having difficulty obtaining your PTIN. It's fairly user-friendly. You need to register in the system and answer some questions and give them your money. That's the bottom line. But if none of that's working for you, they do have a video there, and there's also a link there for contacting us if you need support. Now, what happens if you are outside of the United States? Foreign individuals must now also have a PTIN to be eligible to prepare a tax return for compensation. And foreign persons who prepare U.S. tax returns for compensation who are not eligible to obtain a Social Security number and are neither a citizen of the United States or a resident alien of the United States have to complete Form 8946. They need to apply for the PTIN, and they also need to mail in this Form 8946. The 8946 provides space for them to declare what form of identification they are going to mail in with the application that proves their foreign status. And essentially, they need to attach either an original document or a certified copy or a notarized copy of one of the following pieces of identification that proves their foreign status. If they're able to prove their foreign status to the satisfaction of the IRS, then the IRS will allow them to have a PTIN, and IRS does recommend that you not submit original documents. RTRP competency examination requirement. In late 2011, the IRS established competency testing procedures for all paid tax return preparers who are required to register with the IRS and who are not attorneys, CPAs, EAs, or otherwise exempt from taking the test. The following individuals were exempted, and that includes the attorneys, CPAs, and EAs. It also includes supervised tax preparers who do not sign returns but are employed by an attorney, CPA firm, or other recognized firm that is at least 80% owned by an attorney, CPA, or EA who directly supervises the person who's preparing the return. But also individuals who do not prepare the 1040 series returns were not required to take the test. In Publication 4832, the Return Preparer Review, the IRS stated that it will assess the quality of tax return preparation by those exempted from testing, that is, attorneys, CPAs, and enrolled agents, to determine whether there is a need to expand the competency test to include these individuals in the future. And at that time, the fee to take the test was set at $116. So we're awaiting the outcome of the Loving case to see what form the test will be when it is reintroduced, and presumably if it is reintroduced, it will continue in the same fashion that it was in the future, with those groups of CPAs, attorneys, and supervised preparers being exempt from the test. I know I was personally a little bit surprised that a preparer who could work underneath the supervision of an attorney, CPA, or EA would be allowed to be exempt from the test. I didn't think that was right, and lots of people agreed with that. I even cornered David Williams, the old director of the Return Preparer Office, when he was here at a forum here in Portland, Oregon, and said, "You can't be serious about not requiring everyone to take the test." And he says, "No, we do believe that sometime in the future we will bring these people under the umbrella and require supervised preparers to take the test too." But he was saying that the IRS was just moving in baby steps, and that it wanted as least fuss as possible. And because it was getting pushback from various societies of CPAs in certain states, one I notably remember is Pennsylvania, were opposed to the idea that preparers who work under the supervision of a CPA would need to take this test. So rather than fight it at the time, the IRS took the easy way out, which is to say, well, we're not going to do it for now, but we'll keep that door open for the future. So again, the future is really uncertain now. Notice 2011-6, supervised preparers and non-1040 preparers. In this particular notice, the IRS clarified what the definition of a supervised preparer is, and I've pretty much explained what that is already, but that notice was the first effort the IRS made to make it really clear. Now, if you are a supervised preparer and you are applying for a PTIN, you need to, on the PTIN application, indicate who it is that you work for. So you need to provide information to the IRS about who it is that you work for that's going to be signing the return for you. And the IRS needs to be able to verify that that person is someone who is allowed to supervise you. That is, you need to work for an EA, a CPA, or an attorney. And if you are able to show that and meet all the requirements, then you can be issued a PTIN as a supervised preparer. As we get into the discussion of Circular 230, I wanted you to have some discussion topics in mind. And the discussion topics are actually required. IRS in its regulation states that if you attend an ethics class, there has to be some open discussion in the class, opportunity for participants in the class to think about a real-life scenario, one or more real-life scenarios, and how they would react to that. And so I have a series of discussion topics in today's class. There's 7 of them in total. I'd like you to think about this first one. Jessica is an unenrolled tax return preparer. She is interviewing a new tax return client named George to collect information required to complete his tax return. George is self-employed and operates a small consulting business from his home. He presents a P&L for his business to Jessica with the following items reported on it. His income, he says, is $150,000. He has advertising expense of $1,000, auto is $6,000, consulting $10,000, education $4,000, internet $1,500, miscellaneous expenses $10,000, rent $15,000, payroll $70,000, supplies $10,000, taxes $10,000, travel and meals $15,000, utilities $1,500. His total expenses for the year were $154,000, and he would like her to prepare a tax return that shows he has a loss of $4,000 for the year. What kind of questions do you think Jessica should be asking of him? And I'm going to put a poll up on what kind of questions you think Jessica should be asking of this particular client. FOAL, F-O-A-L, FOAL. Okay, everyone, I asked you all to take a look at group discussion topic number 1 in the student manual. And I put up an open comment field, the types of questions you would be asking of your tax client. And you can see that lots of people have lots of questions they should be asking or have said that they would ask. And they're all really good points. Since there's so many of them, I'm not going to read them out. But I'll tell you what I have to say about this particular tax return. Perhaps the not-so-humorous comment I have to make about this illustration is I just made it up based on the type of thing I see clients throw in front of me on a regular basis. Maybe not this extreme, but sometimes this extreme. And in fact, even this tax season, I had a client of our company who had come here in the last couple of years, worked with one preparer one time, another preparer another time, and this time dropped his stuff off in an envelope. And we had one of our tax preparers on staff start working on it. And then it came across my desk because there were some questions, and the questions were, there was a huge gift expense of $15,000 of gift and things of that sort. And of course, the natural reaction for me is, okay, whoa, this is very suspicious stuff, not necessarily saying or accusing the client of doing anything suspicious, but more questions need to be asked. We can't just put a $15,000 gift expense on the tax return without asking questions and without explaining the law. A key point under the law is that you're not allowed to claim a deduction for a gift given to a person in a year that exceeds $25 in value. So in order to come up with $15,000 worth of gifts, you'd have to have given a lot of gifts to a lot of people, or perhaps it isn't even really gifts at all. Maybe it's something else. So definitely some questions I had for that client, and eventually that client walked and didn't want to deal with the scrutiny or the level of scrutiny I was giving them, and I was perfectly happy to see them go. But let's take a look at George's P&L. We're saying in the wording of the problem that George is operating a small consulting business from his home. And he has presented this P&L. Well, the first thing that comes to my mind is most people that do consulting from home are maintaining a home office, and it's highly unlikely that they have any employees. And so when I come to $70,000 payroll, expense, the first thing I'm thinking is, okay, who did you pay? Obviously, you need to have submitted proper payroll documentation to the IRS and filed 941s, and you need to have, in fact, paid this payroll. And I'm betting that this category that he's called payroll is really money or draws he took for himself. And immediately we would take $70,000 out as an expense, and boom, we've gone from net income of $4,000 to a positive profit of $66,000. And that's before we get into any of these other topics. For example, travel and meals. We know that meals are only 50% deductible. That's an awful big travel expense to begin with. I would ask questions about what the nature of the travel was, what the purpose of the travel was, and make sure that there was a business purpose to it. Same for education. Who was the education for? Was it for you? Was it related to your current line of work? Was it college? Was it for your children? Who was this for? So we could and should go on and ask many, many questions, and not the least of which is this category called miscellaneous expense. $10,000 of miscellaneous? Well, if there's a $10,000 of something that's miscellaneous, that something is not a miscellaneous. It really has an identifiable name, and we need to burrow into that and see what it is. So a good, competent, ethical tax preparer is going to ask questions, and lots of questions, and the law requires that the tax preparer ask questions. If you get a P&L like this and you just slap the numbers on the return and think that that's okay, well, you're going to discover that that's not okay. Maybe not on this particular return, but eventually you're going to discover that it is not okay. So with that, let's return to the next topic of the day, which is the Circular 230 provisions, and I'm just finding the page number I was on, page 17, so we'll pop back to that. So for the next couple of hours, I'm going to try and fit it into 2 hours, we're going to be looking at Circular 230 provisions. And then the final hour of the day, we're going to look at some of the other items out there that every tax preparer should know about, and many of that is further regulations that fall outside of Circular 230, or maybe work in accompaniment with Circular 230. This section of the course provides a summary of certain parts of IRS Circular 230. It is not intended to be a thorough and complete discussion of Circular 230, merely rather to highlight the areas of Circular 230 that I think are the most relevant to most tax practitioners. It is intended to identify and clarify certain content of Circular 230, but I believe every practitioner should read that circular cover to cover, whether you're preparing for the EA exam or not. You really should be familiar with the contents of the publication in its entirety. My purpose today is just to pull out what I think is most relevant and help it sink home. If you are studying for the EA exam, I'm going to be identifying the key topics that you're likely to get questioned on in the EA exam. Now, of course, the IRS has been enjoined from enforcing certain provisions or sections of Circular 230, mainly the RTRP provision, but we'll still discuss what it says in case it does return. Now, according to Circular 230, practice before the IRS covers all matters relating to any of the following: communicating with the IRS for a taxpayer regarding the taxpayer's rights, privileges, or liabilities under laws and regulations administered by the IRS; representing a taxpayer at conferences, hearings, or meetings with the IRS; preparing and filing documents with the IRS for a taxpayer; and corresponding and communicating with the IRS for a taxpayer. The following acts do not constitute practice before the IRS and can be conducted by anybody: furnishing information at the request of the IRS and appearing as a witness for the taxpayer. Now, I'm about to get into the code itself. One of the things you may notice if you ever take a look at Circular 230, and while that's on my mind, why don't I just open it up and we'll take a quick look at it together. Circular 230 is not written by the IRS. It's written by the Department of Treasury. And when the IRS takes tax code and interprets it, it does so with IRS publications, with revenue procedures, and with tax forms and their instructions. And I personally find IRS publications, tax forms, and instructions to be very useful and helpful in understanding the code. I don't actually sit there and read the code. Some professionals do read the code, especially attorneys like to read the code. That's part of the job of being an attorney, to understand the law as it is written. And if you were to appear in tax court at any time, attorneys would be presenting the code and arguing based on the code, and they might present IRS revenue procedures or regulations as an accompaniment to that. But in the end, it's always been my understanding that the code rules, and when the tax court takes a position, it's going to be based on the code and maybe some revenue procedures that the IRS has written, but the revenue procedures don't supersede the code. So at any rate, the bottom line is when you read an IRS publication or an IRS form and its instructions, that is IRS's interpretation of the code, and much of the time it is taken and written in language that is understandable. If you try and read the code itself, your brain starts spiraling. It's understandable, but only if you spend a long time reading it and trying to understand what it means. And unfortunately, IRS Circular 230 is somewhat the same. It is written in code. And if you scroll through Circular 230 and you start trying to read it, it's a lot of fancy legal language. And the farther in it you get, the more confused you might get as you're trying to read it. So what I did in my class today is I took Circular 230 and the provisions that are written in it and basically pulled out key points. I haven't rewritten any of them, but I have shortened them. And, you know, if a paragraph has 100 words in it, I may have shortened it down into just the first couple of sentences because those are the ones that really contain the information we need to know. But again, as I'm going through today's class, I am not explaining all of the rules, and if you need to know all of the rules, then you need to go read Circular 230 in its entirety. So, subject to Section 500 of Title V, the Secretary of the Treasury may regulate the practice of representatives of persons before the Department of the Treasury and, before admitting a representative to practice, require that the representative demonstrate good character, good reputation, necessary qualifications to enable the representative to provide persons valuable services, and competency to assist persons in presenting their cases. This is a pretty strong stance that the IRS is taking. Whether it will be allowed to prevail on this in its entirety remains to be seen. Of course, IRS is taking the stance that in order to prepare a tax return at all, you have to be competent, and that you need to be able to demonstrate that you are competent because you're educated enough to have a level of competency. And you can demonstrate that competency because you have another professional credential like that of a CPA or attorney, or because you've passed the EA test, or because you've passed the RTRP test. The IRS wants to know that you have some level of demonstrated competency. And it's saying in order to represent people, you need to have competency. In September 2011, the IRS revised Circular 230, or the government revised Circular 230, and it now states that a tax return preparer is required to be knowledgeable and competent. The ability to represent a taxpayer before the IRS is considered to be a privilege and not a right. The Secretary may suspend, disbar, or censure a representative who is incompetent, disreputable, violates regulations prescribed under this section, or with willful intent to defraud, willingly and knowingly misleads or threatens the person being represented or a prospective person to be represented. Monetary penalty may be imposed on the tax preparer. The Secretary may also impose a monetary penalty on the representative. The employer or firm may also be subject to sanction or penalty. If the representative was acting on behalf of an employer, firm, or other entity in connection with the conduct giving rise to the penalty, the Secretary may impose a monetary penalty on the employer, firm, or entity if it knew or reasonably should have known of the unethical conduct. The penalty shall not exceed the gross income derived or to be derived from the conduct giving rise to the penalty, and may be in addition to or in lieu of any suspension, disbarment, or censure of the representative. Now, after notice and opportunity for a hearing to any appraiser, the Secretary may provide that appraisals by the appraiser shall not have any probative effect in any administrative proceeding, and also bar the appraiser from presenting evidence or testimony in the proceeding. So although Circular 230 basically covers the tax preparation industry, it also, and a little sideline here, does cover appraisers, and that is because appraisers are asked to do appraisals with regards to positions taken on tax returns, either the evaluation of property in an inheritance, for example, the appraisal of property in a divorce, and if the IRS deems that an appraisal has been grossly negligent, the appraiser can be barred from having their appraisals set forth before the IRS. Nothing in this section or in any other provision of law shall be construed to limit the authority of the Secretary of the Treasury to impose standards applicable to the rendering of written advice with respect to any entity, transaction, plan, or arrangement, or other plan or arrangement, which is of a type the Secretary determines as having a potential for tax avoidance or evasion. Now, up in this section right here, Section B, I think there's some pretty important stuff being said. The IRS says that it can disbar or censure or suspend a representative who is incompetent, disreputable, violates the regulations, or with willful intent knowingly misleads or threatens a person. Karen Hawkins really kind of summarizes that somewhat. Karen Hawkins is the director of the Office of Professional Responsibility. The Office of Professional Responsibility is the office of the IRS that is charged with overseeing the tax preparation industry for misconduct. If you get a letter from OPR, it's not a good day for you. It means they're taking a close look at you and that you're probably in trouble. Karen Hawkins is in charge of that entire organization and frequently speaks on what types of actions the IRS is currently engaged in and the types of things that the IRS is looking at. And you can go and read information on the IRS website under a category called Tax Notes Today. It's essentially a publication with newspaper-type articles that are written about what types of activities that are going on. And on the 2/22 of 2012 article, an article was published, and it said, although the IRS Office of Professional Responsibility has the authority to penalize practitioners or their firms through monetary sanctions, OPR Director Karen Hawkins has said that she is reserving that penalty for firms only. I'm saving it for firms because I don't want practitioners to ever get the impression that they can buy their way out of a disciplinary matter by throwing some money at me. I want to use monetary sanction where it has the most impact. Well, if you think about it, there's been a number of pretty public cases over the last 10 years or so where national companies have been on television because secret investigators or hidden camera investigators have gone in and caught them doing disreputable conduct activities. And Karen Hawkins is looking at those institutions and saying, although the employee was doing something wrong, odds are the employee was doing so under the direction of the employer. And so although that employee could be fined or disbarred for engaging in unethical conduct, it could very well be interpreted and should be interpreted that very often an employee is acting under the instructions of their employer and may not even be aware that what they're doing is wrong, but that the employer has an obligation to know what is wrong. And if it can be determined that the employer is the reason that the action was being taken by the employee, then Karen Hawkins wants to go after the company more than the employer. Section 10, Scope of Part, Subtitle A, Part 10, Title 31 of the Code of Federal Regulations contains rules governing the recognition of attorneys, CPAs, enrolled agents, enrolled retirement plan agents, and registered tax return preparers, as well as other persons who represent taxpayers before the IRS. Subpart A essentially goes into rules governing the authority to practice and tells us, to begin, just as an introduction, that there are two separate offices. There used to be only one office, the Office of Professional Responsibility, but in 2011, IRS split itself in half, you could say, and created two offices. And we now have the Office of Professional Responsibility, for whom Karen Hawkins is the current director. And we also have the Return Preparer Office, who is currently directed by Carol Campbell. OPR has responsibility for matters relating to practitioner conduct and discipline, including disciplinary proceedings and sanctions. That's why I'm saying if you get a letter from OPR, you're probably in trouble. The Return Preparer Office, by contrast, is responsible for implementing the new requirements and for oversight of the IRS Return Preparer Program. OPR is the office that currently administers the enrolled agent exam and the RTRP test while it was in play. It's also responsible for setting up the standards for collecting continuing education information. Another news article that came out was a BNA Daily Tax Report press release that was issued by OPR back on 2/24 of last year, and it provided the following information. It clarifies OPR's role and that OPR has jurisdiction over the following individuals: CPAs and attorneys who practice before the IRS, all enrolled agents and enrolled retirement plan agents, enrolled actuaries, paid return preparers, and appraisers who submit appraisals supporting tax positions. It describes the four broad areas in which OPR may identify areas of misconduct by a tax practitioner, which include when advising taxpayers on filing positions or transactions, during taxpayer representation before the IRS, on the practitioner's own return, and also external misconduct or moral turpitude. What this is saying is that OPR can come down on a preparer not just because the preparer engaged in misconduct before the IRS in terms of preparing a tax return or representing a client, but they can also look at that tax practitioner's own return and deem that a practitioner is unethical or is exhibiting misconduct because of how they prepared or presented their own tax return. And finally, completely away from the tax preparation world, that tax return preparer can be looked at for their own private behavior, public or private, and whether or not that is considered to be misconduct. So for example, if you steal or become convicted of fraud, nothing to do with tax returns, but you have that stamp of disapproval from another agency on you, that the IRS can look at that and say, hey, that's ground for disbarment or for us to look at you for misconduct. All complaints about practitioner misconduct are referred to OPR. However, a tax preparer's own noncompliance or tax compliance is checked by the return preparer office, which will issue soft letters to noncompliant tax practitioners to urge them into compliance. This is the new logo, or a recently new logo, for the return preparer office. The Return Preparer Office works in partnership with the Office of Professional Responsibility, which is responsible for the enforcement of Circular 230 conduct issues. Now, the next part of Circular 230 is a series of definitions. It goes on to describe who an attorney is, who a CPA is, who the commissioner is, what constitutes practice before the IRS. So let's take a look at what practice means. Practice comprehends all matters connected with presentation to the IRS or any of its officers or employees relating to a taxpayer's rights, privileges, or liabilities under laws or regulations administered by the IRS. Such presentations include, but are not limited to, preparing documents, filing documents, corresponding and communicating with the IRS, rendering written advice with respect to any entity, transaction, plan, or arrangement, or other plan or arrangement having a potential for tax avoidance or evasion, and representing a client at conferences, hearings, and meetings. It goes on to describe who a practitioner is, what a tax return is, what the service is, and so on. And then it gets into Section 10.3, who may practice. Any of the following individuals can practice before the IRS. However, any individual who is recognized to practice, that is a recognized representative, must be designated as the taxpayer's representative by a power of attorney. Form 2848 Power of Attorney and Declaration of Representative can be used for this purpose. So obviously attorneys who are currently in good standing and not under disbarment or suspension, they have to be in good standing and obviously legal in their state or territory. The same for CPAs. Any CPA who is not currently under suspension or disbarment from practice before the IRS and who is duly qualified to practice as a CPA in any state, possession, territory, Commonwealth, or the District of Columbia may practice before the IRS. An enrolled agent in good status or active status may practice before the IRS. Same is true of enrolled actuaries and enrolled retirement plan agents. We then have an entire section here, a much longer section written on registered tax return preparers. And I'm going to go in and read this even though we're in limbo on it. Any individual who is designated as a registered tax return preparer pursuant to Section 10.4 of Circular 230 who is not currently under suspension or disbarment from practice before the IRS may practice before the IRS, but practice as a registered tax return preparer is limited. Now, at this point in time, we don't have registered tax return preparers. We just have unenrolled tax preparers. And so when I read what's coming next, you can say that this applies to you if you are not an enrolled agent, CPA, enrolled actuary, attorney. In other words, if you're none of those things, you are an unenrolled tax preparer, and these rules apply to you. Practice as an unenrolled or registered tax return preparer is limited to preparing and signing tax returns and claims for refund and other documents for submission to the IRS. A registered tax return preparer may prepare all or substantially all of a tax return or a claim for a refund of tax. The Internal Revenue Service will prescribe by forms, instructions, or other appropriate guidance tax returns and claims for a refund that a registered tax return preparer may prepare and sign. A registered tax return preparer may represent taxpayers before revenue agents, customer service representatives, or similar officers and employees of the IRS, including the Taxpayer Advocate Service, during an examination if the RTRP signed the tax return or claim for refund for the taxable year or period under examination. What this is saying is a registered tax return preparer / unenrolled tax preparer is not allowed to have a power of attorney and cannot represent a taxpayer before the IRS unless they prepared the tax return that the IRS is examining. If they didn't prepare the return, the best they can do is perhaps assist with gathering information for the taxpayer to represent their own case before the IRS, but they're not going to be able to represent a case to the IRS for their client unless they prepared the return. Unless otherwise prescribed by regulation or notice, this right to represent a taxpayer does not permit such individual to represent the taxpayer regardless of the circumstances requiring representation before appeals officers, revenue officers, counsel, or similar officers or employees of the IRS or the Treasury Department. So let's just suppose you did prepare a tax return as an unenrolled tax preparer, and the tax return is audited. You are allowed to represent your client before the IRS with regards to that audit because you did prepare the return. But if the audit goes in a direction that neither you nor your client likes and it needs to be appealed, you're not going to be able to do the appeal. Only an enrolled agent, a CPA, or an attorney is going to be able to go through that appeal process. And that's a pretty valuable thing, to be able to appeal a tax return. I've certainly done it myself on more than one occasion where I highly dispute the outcome that the particular auditor came to, or basically they said that the tax return needed to have this change done to it, or this particular position was not acceptable. I highly disagreed, and so it went to appeal. I can do that because I'm an enrolled agent. If you're an attorney or CPA, you can do the same thing, but if you are an unenrolled tax practitioner, basically your client's going to be on their own unless you have someone else in your firm who is an enrolled agent, CPA, and attorney and can help them through that. Also, a registered tax return preparer's authorization to practice does not include the authority to provide tax advice to a client or another person except as necessary to prepare a tax return, claim for refund, or other document intended to be submitted to the IRS. That is a pretty standout comment, I feel. What exactly does tax advice mean? IRS says you can't give tax advice except with regards to preparing the tax returns currently in front of you. So if you have your own tax service, you're in business as a tax preparer, you're unenrolled, client comes into you, sits down at your desk and says, yeah, I'm considering doing this investment or that investment, and I wanted to get your tax advice on this or that, and you're not actually preparing their tax return, the IRS is saying, well, you can't do that. And there's a few people who are kind of wondering about that, especially here in the state of Oregon, because in the state of Oregon, where I'm teaching from, we have a category of tax preparer called a licensed tax consultant. We also have a category of tax preparer called a licensed tax preparer. And just a brief summary of the difference between the two, a licensed tax preparer has to take an approved 80-hour course in tax law and pass a 5-hour examination with 200 questions covering tax law, individual tax law. When they pass that, they get an apprentice-level license that allows them to work under the supervision of a licensed tax consultant, and they must do so for a minimum of 2 to 5 years and obtain 1,100 hours of work experience before they can move on and take another higher-level test called the LTC exam. And the LTC exam is a very difficult exam. In many ways, it's more difficult than some of the questions asked in the EA exam, but at the very minimum, it's comparable to it. And so preparers who have passed that test and gotten the years of experience really do feel that they are tax consultants, especially when they have a license that says they are. And so, of course, I was attending an IRS forum here in Portland, Oregon in November of 2011. And this question was on my mind, but I didn't have to ask the question because another person in the room got up and asked it for me. And that's this little outtake right here. The subject of authority to provide tax advice, this particular restriction was a subject of concern expressed to David Williams, who was at that time the director of the Return Preparer Office. And the question was posed by an Oregon LTC. The preparer said, are you telling me I can't consult? My name is licensed tax consultant. I have that credential, and you're telling me I can't consult? And David Williams really downplayed that, saying, no, that's not what we mean. That's not what we're trying to prevent you from doing. My opinion is that if that's the case, then it needs to be worded a little bit differently, because this particular paragraph is clearly and distinctly saying that you're not allowed to give tax advice. So we'll see where that goes in future revisions of Circular 230. Now, I did notice earlier, and then I forgot to answer it, that there was a question posed. I have a question about firms that are not run by a tax attorney or a CPA. Can I, as a tax preparer, run my own business under the current IRS standards? Well, that would depend on what state you're in. If you're in California or Oregon, there are much more stringent standards than those imposed by the IRS, and you would have to meet the standards at the state level. If you are working outside of those states, odds are you're not regulated in any way. There are some small regulations in the state of Maryland as well as New York. Those are easy standards to meet. All you really essentially have to do to be in business as a tax preparer is have a PTIN. So if you've registered and gotten a PTIN, you can be in business. But we're going to talk about what it takes to actually conduct your business legally And so there can be a lot more than just being and calling yourself a tax preparer and hanging up your shingle. There may be some other actions you need to take. But at this point, there's no requirement to take the RTRP test. There is no requirement to take continuing education. In fact, there's no requirement that you know anything about tax law at all in terms of a procedure. There's no procedure for proving that you're competent. But the IRS within Circular 230 is still saying that you need to be competent. Now, you don't need to be competent to own a tax service. Even in the state of Oregon, you can own a tax service without being a tax preparer. But anyone in this state who prepares a tax return has to be competent. And essentially that's what IRS is saying, is that in order to prepare a tax return, you have to be competent to do so. And owning a tax service and preparing a tax return can be two different things. And case in point is myself. I got into this business back in 1992. I actually purchased a national tax franchise in the city of Portland back in November of 1992. And at that point, I was so ignorant on tax law, I did not even know what the 1040 was. You might say, how could anyone not know what the 1040 form was? And the answer is, well, I came from Canada. They don't have 1040 there. I married an American. He was in the military. As he was getting out of the military, he decided he wanted to get a franchise of some kind. I said, let's buy this tax franchise. And basically the figuring was that because he had a degree in accounting and I was smart enough to learn, that we could run a tax business. So we arrived in Oregon. We purchased this franchise and we hired Oregon licensed tax preparers and consultants to work for us. So that made our business perfectly legal under the state of Oregon laws, and really under ethics requirements of Circular 230, it was legal too. We were not touching tax returns that we knew nothing about. We were paying people who presumably had demonstrated minimum competency requirements by adhering to Oregon licensing standards. So again, if you're looking at yourself outside of the state of Oregon, what I would be concerned about is, are you in compliance with Circular 230? And you are in compliance with Circular 230 if you can demonstrate that you're competent. So who cannot practice before the IRS? Well, the current Circular 230 does not state who cannot practice before the IRS. You may have noticed it's common practice of the IRS to only say what you are allowed to do. And the insinuation is that if they haven't told you you can do it, then probably you can't do it. There are some exceptions to that. If you were to read Publication 17 and you get into the section on itemized deductions, it does have a list about 2 pages long of examples of things you're not allowed to deduct. One of the most noteworthy among those is, of course, the wristwatch. The argument being, I need a wristwatch to show up to work on time, and the IRS is saying, forget it, wristwatches are not deductible by anybody. And so Circular 230, it tells you who can practice, and then we're wondering who cannot practice. So I noticed that it was no longer saying who cannot practice, so I went back to the old version of Circular 230 where IRS did go out of its way to say who cannot practice, and I've just left that in my course in case you're wondering. In general, individuals who are not eligible or who have lost privileges as a result of certain actions cannot practice before the IRS. If an individual loses eligibility to practice, his or her power of attorney will not be recognized by the IRS. Corporations, associations, partnerships, and other persons that are not individuals. These organizations are not eligible to practice before the IRS. So in other words, if your business is a corporation, the corporation cannot represent a taxpayer. There needs to be an individual who is competent and is selected within that firm who will do the representation. Also, government officers and employees and others, most of these individuals are not authorized, as are state officers and employees. Many of those are not authorized to practice before the IRS as well. Section 10.4, eligibility to become an enrolled agent, enrolled retirement plan agent, or registered tax return preparer. Enrollment as an enrolled agent upon examination. There are essentially 2 ways you become an enrolled agent. The way that I think of, and many of you probably think of, is, well, you sit the enrolled agent exam and you pass it. But it's also possible to become an enrolled agent simply because you worked for the IRS for long enough. So becoming an enrolled agent, the commissioner or delegate will grant enrollment as an enrolled agent to an applicant who is age 18 or older, demonstrates special competence in tax matters by written examination administered by or administered under the oversight of the IRS, possesses a current or otherwise valid preparer tax identification number, and has not engaged in any conduct that would justify the suspension or disbarment of any practitioner under the provisions of this part. For enrollment as a registered retirement plan agent or enrollment as a retirement plan agent, pretty much all of the same rules, except you take the enrolled retirement plan agent test instead of the special enrollment test. Designation as a registered tax return preparer. This individual is an individual who is age 18 or older, demonstrates competence in federal tax return preparation matters by passing a written examination, possesses a current or otherwise valid PTIN, and has not engaged in any conduct that would justify suspension or disbarment. Enrollment of former Internal Revenue Service employees. The commissioner or delegate may grant enrollment as an enrolled agent or enrolled retirement plan agent to an applicant who, by virtue of past service and technical experience with the IRS, has qualified for such enrollment and who has not engaged in any conduct that would justify suspension or disbarment of any practitioner under the provisions of this part. And then it goes on to all of the rules that apply to a former IRS employee that would allow that individual to become an enrolled agent. They have to have a certain number of years of experience and have a supervisor sign off on that experience. Application to become an enrolled agent. How do you become an enrolled agent? Well, you have to fill out a form and mail it to the right address, or these days you do it online. And you have to pay a fee. You also have additional information and an examination. The IRS may require the applicant to provide additional information and to submit written or oral examination. And of course, most of us are seeing that the IRS is giving examinations via computer these days. Compliance and suitability checks. The IRS may conduct a federal tax compliance check and a suitability check. The tax compliance check verifies whether an applicant has filed all required individual or business tax returns and has paid or made arrangements to pay all debts. The suitability check verifies whether the applicant has not engaged in incompetent or disreputable conduct. If the applicant does not pass the tax compliance or suitability check, the applicant will not be issued an enrollment or registration card. An applicant who is denied enrollment or registration for failure to pass a tax compliance check may reapply if the applicant becomes current with respect to the applicant's tax liabilities. Temporary recognition. The IRS can give temporary recognition in certain unusual circumstances. And protest of application denial. If an applicant is denied, they have 30 days to file a written protest. Term of renewal of status as an EA, enrolled retirement plan agent, or registered tax return preparer. There is a term, of course, for each renewal. For EAs, the renewal period is 3 years, and for registered tax return preparers, the renewal period is 1 year. And regardless of the renewal period for your credential, you still have to renew the PTIN every year. Let's go on and talk about the renewal. In general, enrolled agents, enrolled retirement plan agents, and registered tax return preparers must renew their status to maintain eligibility to practice before the IRS. And failure to receive notification from the IRS of the renewal requirement will not be justification for the individual's failure to satisfy this requirement. The IRS actually has a rule that says if you move, you have to notify the IRS, and it's right here, change of address. You have to notify the IRS within 60 days of the fact that you changed your address. So if you moved and then you didn't get a renewal notice, you can't claim to the IRS that, hey, I didn't know I was supposed to renew. I never got the notice. That won't be an acceptable justification, and also it might even be proof that you moved without submitting a change of address. So it's your responsibility to know when your renewal period is. And if you are an unenrolled tax preparer, or actually if you're a PTIN holder in general, all PTIN holders have to renew every year, and the renewal period is mid-October through December. For enrolled agents, it's a little more confusing. All enrolled agents must renew their PTINs annually, but in addition to that, they must renew the enrolled agent status every 3 years as determined by the last digit of the taxpayer ID number, in other words, the Social Security number. Applications for renewal of enrollment must be submitted between November 1 and January 31 prior to April 1 of the year that your next enrollment cycle begins. Well, that's a little bit of a head spinner in terms of what it's trying to say, so here's what it says. If your SSN or TIN ends in a 0, 1, 2, or 3, your enrollment cycle began April 1st, 2013, and your renewal period was between November 1, 2012 and January 31, 2013. What that meant was that between November 1, 2012 and January 31, 2013, if your Social Security number ended in a 0, 1, 2, or 3, you needed to go online and you needed to submit your renewal application and provide information relating to your continuing education that you had met those requirements. And you needed to complete that by January 31, and if you did, then you are in your enrollment cycle, which begins April 1st, 2013, is going to be current and valid. For individuals with Social Security numbers ending in a 4, 5, or 6, Your enrollment cycle begins April 1st, 2014. Your renewal cycles between November 2013 and January 31, 2014. And for those with the 7, 8, or 9 as the last digit of the Social Security number, the next enrollment cycle begins April 1st, 2015, and the renewal will occur November 1st, 2014 through January 31st, 2015, beginning more than a year out from now. It is the EA's responsibility to apply for renewal by timely filing Form 8554 and paying the $30 renewal fee. Renewal period for enrolled retirement plan agents. All enrolled retirement plan agents must renew their PTINs as prescribed by the IRS, and there's information here if you happen to be an enrolled retirement plan agent. Renewal period for RTRPs, again, it's basically October 18 through December 31 is the renewal period. Notification of renewal. After approval, the IRS will issue the individual a card or certificate showing the current status as an enrolled agent, enrolled retirement plan agent, or registered tax return preparer. And of course, RTRPs are left in limbo right now with nothing getting renewed other than the PTIN. Condition for renewal as an EA is continuing education, also for enrolled actuaries and enrolled retirement plan agents. All of those three categories have to get CE. And if you are an unenrolled tax preparer, you are also supposed to have CE. It's just that the IRS cannot force you to get it at this time. And here are the rules for EAs. Renewal of enrollment requires a minimum of 72 hours of continuing education, including 6 hours of ethics or professional conduct, must be completed during each enrollment cycle. And the enrollment cycle is 3 years. And a minimum of 16 hours of continuing education credit, including 2 hours of ethics or professional conduct, must be completed during each enrollment year of an enrollment cycle. So if you are an EA, you can never have less than 16 hours in a year. But the average per year should be 24 hours because 24 times 3 gets you to 72. So you can have less than 24 hours in a year, but not less than 16. And certainly you could have 16 in 1 year. You could have 16 in 2 years, but in the last year you're going to have to make up for it with more hours. An individual who receives initial enrollment during an enrollment cycle must complete 2 hours of continuing education credit for each month enrolled during the enrollment cycle, and enrollment for any part of a month is considered enrollment for the entire month. 2 hours of ethics education must be completed every year, including the first year. Registered tax return preparer renewal. Assuming these requirements are reinstated, the minimum requirement is 15 hours of CE every year. And enrolled agents are required to have 2 hours of ethics, and then the remainder of their annual requirement can be on federal tax law. But for unenrolled tax preparers, the IRS is more specific. It says you need to have the 2 hours of ethics. You also need to have 3 hours of federal tax law update, and then the rest of the CPE can be federal tax law topics. Qualifying continuing education, you need to take education that does meet IRS specifications. So if you just go out and get any old education, it may not qualify. So here is what IRS deems to be qualifying education. The CPE must be from a program designated to enhance professional knowledge in federal taxation or federal tax-related matters, including accounting, tax return preparation, software, taxation, or ethics, and be a qualifying continuing education program. If you're an enrolled retirement plan agent, then the tax law covered must be in qualified retirement plan matters. Registered tax return preparers, it must be a qualifying continuing education program designed to enhance professional knowledge in federal taxation or federal tax-related matters, including accounting, tax preparation, software, taxation, or ethics, and be a continuing education program. Qualifying programs, a formal program qualifies as a continuing education program if it requires attendance and provides each attendee with a certificate of attendance. It must be conducted by a qualified instructor, discussion leader, or speaker whose background, training, education, and experience is appropriate for the subject matter of the particular program. It must provide or require a written outline or suitable electronic educational materials. So for example, in today's class, I'm teaching from a manual. It's on the screen in front of you. Our school is required to either provide this manual to you or some other outline. And of course, we've provided you the manual in its entirety. And so you need to, if you've not already done so, download that manual and keep it on your computer, and you'll see why in a minute. Also, the provider must satisfy the requirements established for a qualified continuing education program, or the education must satisfy the requirements. Correspondence or individual study programs. Qualifying continuing education programs include correspondence or individual study programs that meet the following conditions. They are conducted by continuing education providers and completed on an individual basis by the enrolled individual. The allowable credit hours for such programs will be measured on a basis comparable to the measurement of a seminar or course for credit in an accredited educational institution. Require registration of the participants by the continuing education provider. Provide a means for measuring successful completion by the participants. For example, a written examination, including the issuance of a certificate of completion by the continuing education provider. Provide a written outline, textbook, or suitable electronic educational materials, and satisfy the requirements established for a qualified continuing education program. Serving as an instructor, discussion leader, or speaker. You might be asking yourself, okay, sometimes I teach tax law. Am I allowed to receive continuing education when I am the instructor? And the IRS says yes, to a point. 1 hour of continuing education credit will be awarded for each contact hour completed as an instructor, discussion leader, or speaker at an educational program that meets the continuing education requirements of this section. A maximum of 2 hours of continuing education credit will be awarded for actual subject preparation time for each contact hour completed as an instructor, discussion leader, or speaker at such programs. It is the responsibility of the individual claiming such credit to maintain records to verify preparation time. So if you are an instructor and you want to receive CE for the time you put into preparing to teach a class, you're going to have to keep a log, a written log, of the time and days that you put into preparing for the class. The maximum continuing education credit for instruction and preparation may not exceed 4 hours annually for a registered tax return preparer or 6 hours annually for enrolled agents and enrolled retirement plan agents. So that's a pretty small number. 6 hours annually. If you're teaching a 2-hour class, odds are you spent at least 6 hours getting ready for that class, and that's all you're going to get credit for in that whole year. And the remaining of the average of 24 hours for each year for an enrolled agent is going to have to be obtained from somewhere other than yourself. An instructor, discussion leader, or speaker who makes more than one presentation on the same subject matter during an enrollment cycle or registration year will receive continuing education credit for only one such presentation for the enrollment cycle or registration year. So what that's saying is you can only get credit for completing a course once, whether you're teaching it or taking it, in each enrollment cycle. For enrolled agents, an enrollment cycle is every 3 years. So theoretically, what I'm seeing in that is that once every 3 years is all you can take a particular program from a particular instructor and receive credit for that. But for RTRPs, the enrollment cycle is only 1 year. So an RTRP could take a course 1 year and then the next year take the exact same course and it would be okay because the enrollment cycle is only 1 year long. But for EAs, IRS is saying no, once every 3 years is how often you can take a course and receive credit for it. Periodic examination. Enrolled agents, enrolled retirement plan agents may establish eligibility for renewal of enrollment for an enrollment cycle by achieving a passing score on each part of the special enrollment examination administered under this part during the 3-year period of enroll and completing a minimum of 16 hours of qualifying continuing education in the last year of the enrollment cycle. So just let's suppose you're an EA and it's just been a bad couple of years. You didn't get any continuing education in. You were supposed to do 16 hours a year and you didn't do any. And now you're in the final year of your enrollment cycle. What do? The IRS says, well, you need to get the 16 hours for sure in that final year, and then you can go sit and pass all 3 parts of the EA exam again. And if you pass all 6 parts of that exam, they'll allow you to renew. Measurement of continuing education coursework. All continuing education programs will be measured in terms of contact hours. The shortest recognized program will be 1 contact hour. A contact hour is 50 minutes of continuous participation in a program. Credit is granted only for a full contact hour, which is 50 minutes or multiples thereof. A program lasting more than 50 minutes but less than 100 minutes will count as only 1 contact hour. So one of the things that we deal with at Pacific Northwest Tax School is sometimes we have programs that really would nicely fit into a half-hour increment. This course isn't really 5 hours long, but it's certainly 4.5 hours long. What are we going to do? So very often we're trying to come up with more content to stretch it out to 5 hours, or we're trying to figure out how to weed it down so it fits into 4 hours. Because if we make a program run 4.5 hours, the IRS will only give credit for 4 hours. So that is one of the problems that does come from this particular rule. So if you are attending a CE program and the program is 90 minutes long, for example, you're only going to get 1 hour of continuing education for that program. They may give you a certificate that says 90 minutes or 1.5 hours, but you will actually only receive 1 hour of credit from the IRS for that. And that's not a unique rule. Every state is going to be different for CPAs and attorneys on whether they will give credit for a half hour. But at the state level, certainly here in Oregon and California, tax preparers have to get full hour increments, and IRS is imposing that same rule. Respective of that rule, or regardless of that rule, individual segments at continuous conferences, conventions, and the like will be considered one total program. For example, 2 90-minute segments totaling 180 minutes at a continuous conference will count as 3 contact hours. For university or college courses, each semester hour credit will equal 15 contact hours, and a quarter hour credit will equal 10 contact hours. Record-keeping requirements. For CPE programs completed, the following information must be retained for a period of 4 years following the date of renewal: the name of the sponsoring organization, the location of the program, the title of the program, the qualified program number, and a description of its content. Written outlines, course syllabi, textbook, and/or electronic materials provided or required for the course, the dates attended, the credit hours claimed, the name of the instructor, discussion leader, or speaker if appropriate, and the certificate of completion and/or a signed statement for the hours of attendance obtained from the continuing education provider. So what this is telling you is that the manual that we asked you to download, you need to download it. It's a requirement for maintaining proof of your continuing education. And you should also download and keep a copy of your certificate of completion for the course and maintain that. So for services completed as an instructor, discussion leader, or speaker, the following information must be maintained for a period of 4 years following the date of renewal: the name of the sponsoring organization, the location of the program, the title of the program or a copy of its content, the dates of the program, and the credit hours claimed. Waivers from the continuing education requirements may be granted for the following reasons: health, which prevented compliance with the continuing education requirements; extended military duty; absence from the United States for an extended period of time due to employment or other reasons, provided that the individual does not practice before the IRS during that period of absence; and other compelling reasons which will be considered on a case-by-case basis. You should refer to Publication or Circular 230, page 16, for restrictions and information on how to apply for a waiver. So let's take a look at question number 2. It says, Jack is an enrolled agent. He is preparing a tax return for John, who filed bankruptcy during the year. John wants to claim a deduction for attorney fees he paid, and what kind of questions should Jack ask? Well, in most cases, attorney fees are probably not going to be deductible. There really has to be a business reason for paying an attorney fee, or it has to be paid with regards to collection of taxable income. So, for example, if you hire an attorney to sue your former spouse for alimony that is in arrearage, that is an allowable deduction on Schedule A. But attorney fees that you might have paid for a bankruptcy are certainly not deductible on Schedule A. And if your client did file bankruptcy during the year and then wants to claim a deduction for attorney fees that he paid during the year, it's kind of self-evident that you're probably going to be wanting to ask that person, how come you paid attorney fees? Did they have to do with your bankruptcy? Because if they did, they're certainly not deductible. Is it a business matter or a personal matter? If it was for the bankruptcy, it's not deductible. What were the attorney fees for? Those are all appropriate questions that a diligent tax preparer should be asking. Moving on to the next question, which is problem number 3. I'll just stretch this out so you can read a little bit more. Considering IRS ethics rules surrounding best practices with regards to giving tax advice, how would you respond to a client who makes the following statement? I received some unemployment during the year, but I don't know how much. I just want to leave that off my return, and I'll deal with it next year. And how often have we heard that? I've certainly heard that kind of comment far too many times. In fact, clients are so good at omitting information that I feel it's part of my due diligence as a tax preparer to ask them questions about every conceivable form of income they might possibly have had, just in case they have it but didn't tell me about it. So when I'm preparing a tax return, I actually have a checklist of all of the different types of income that a person might have, and I ask them if they had those types of income. And as I'm going through that list, I'm checking yes or no to their responses. And if I get to a point where they say, yes, I had some unemployment income during the year, then the next question is, okay, where is the unemployment 1099-G that the government should have issued to report that unemployment? And if they don't have it yet, then I need to tell them to go get it. And certainly under no situation should you ever tell a client, well, you didn't get the unemployment document, so we'll just pretend you never got that. You know, if IRS figures it out, they'll send you a letter and assess some tax in the future, but, you know, for today, we'll just file without it. That's okay. That would be a completely inappropriate way to respond. It would be a violation of ethics rules. It would be a willful filing of an incorrect return and possibly subject you to numerous penalties. So you can see all of the comments coming in here. 24 responses did come in, and the answer is over and over again, no, you cannot leave it off the return. That would be illegal. And then moving on to the next one, this particular question relates to the cartoon that you see below you. And I like to take credit for this cartoon. It was a creation of my imagination. I'm not an artist. I did have an artist who works for me draw the pictures, but I told them what to draw, what I wanted them to see. Because kind of as a passing joke in our firm for many, many years, we've talked about computer cripples. Someone that is a tax preparer who relies so much on the tax software that whatever the tax software says is the answer, that they don't think about what it is that they're looking at. And this can be the case whether you're looking at a first-year tax preparer, it's their first season doing tax returns, or whether you're looking at a tax preparer who's maybe been doing tax return for 10 years or more. There are certain preparers who let the computer do the thinking and don't engage their brain. And if you happen to have that kind of preparer working in your firm or working underneath you, that really is an ethics issue. Because what that preparer does within your firm or does sitting at the desk next to you does have ramifications for your business as a whole. And if your firm develops a reputation of having incompetent tax preparers working at the desk, then that's going to fall back on you. It's either going to come out in Google and Yelp reviews about what people have to say about the quality of the service that they're getting from you. It has to do with the types of things they say to their friends. And ultimately, if a client that a tax return was prepared for ends up in an audit and says that the tax preparer didn't seem to know what they were doing, that could mean that the IRS is going to start taking a closer look at perhaps other tax returns prepared in your firm, and that can have a negative impact on the revenue of the firm and on your income as a tax preparer. So there's so many reasons why having competent, ethical tax preparers working under you within the firm that you are employed by is crucially important. And this is before we even get to the issue of whether or not you are in compliance with ethics rules, because under IRS ethics rules, you're required to be competent. And when we look at this particular cartoon, which says, we've obviously got Mr. Tax Preparer and Miss Tax Client, and he's saying your refund is $150. And the little computer here is saying $150 refund. And the client is saying, but my refund was $2,500 last year. Why is it so low this year? Well, before that client ever asked that question, a good tax preparer would know that she would ask that question, because a good tax preparer would already have looked at last year's tax return and seen what last year's refund was. And when this year's refund comes up at $150, it's a given the client's going to want to know why there's a difference, and the preparer should know why there's a difference before they open their mouth and even say what the refund is. And quite frankly, I use last year's tax return refund, assuming it's correct, and this year's tax refund to look for errors in my own work. Do I have a data entry error? Did I leave off a particular W-2? Did I transpose a digit? Did I leave a digit off? Maybe the withholding I should have entered was $2,500, but I accidentally entered $250. And so when I process that tax return and I get to the end, how those numbers line up on the tax return as I'm reviewing through it should make sense to me. And if they don't make sense to me, then I should fix them before my client knows that I made a mistake. Because after my client finds out I made a mistake, their estimation of my skill has dropped significantly. And, ooh, I missed that. And, ooh, let me fix that. Never makes you look good or competent in the eyes of your tax client. But things get worse in this situation because the preparer is so clueless, it doesn't occur to him that there could be a reason that needs to be explained, and he certainly can't explain why there's a difference. So he just says, well, my computer says the refund is $150, and that's what it is. And the client is saying why, as she's entitled to know why. She's paying this preparer to tell her why, and he does not know. And of course, he's just saying, well, the tax software says it's 150, therefore it is. And clearly he is what we refer to in our firm as a computer cripple. All right, so with that, let's close out this particular survey. And we're going to move on back into the manual where we left off, which was in the vicinity of page 30 or so. So we're on to item J, failure to comply, which is on page 31 of your manual. Individuals who fail to meet the continuing education and fee requirements for renewal will receive a letter of noncompliance and will be given an opportunity to furnish the requested information in writing within 60 days of the notice. If renewal is denied, an individual may file written protest within 30 days after receipt of the notice of denial or renewal. CPE records may be reviewed to determine compliance with IRS requirements. Individuals may be required to provide copies of CPE records, and failure to supply these records can be cause for the CPE to be disallowed. An individual who fails to file a timely renewal and does not make a timely response to a notice of noncompliance will be placed on a roster of inactive individuals and is not eligible to practice before the IRS. Individuals placed on inactive or ineligible status may not state or imply that they are eligible to practice before the IRS. An individual placed on inactive status may be reinstated to active status by filing an application for renewal and providing evidence of completion of all required CPE. Application for renewal and required CPE must be submitted within 3 years of being placed on inactive status. Inactive status is not available to individuals who are the subject of a disciplinary matter before the IRS. So what this is saying is if you are notified by the IRS that you're going to be disciplined, you can't just put yourself on inactive status and hope that solves the problem, because it won't, and you're not allowed to do that. Inactive retirement status. An individual who no longer practices before the IRS may request to be placed on inactive retirement status. The individual will be ineligible to practice before the IRS during that time. The status may be reinstated to active by filing an application for renewal and completion of the required CPE hours. And inactive retirement status is not available to an individual who is ineligible to practice before the IRS or is the subject of a pending disciplinary matter. Renewal while under suspension or disbarment. An individual who is ineligible to practice before the IRS by virtue of disciplinary action under this part is required to conform to the requirements for renewal of enrollment or registration before that individual's eligibility is restored. So what this is saying is during a period of time of ineligible status, either because you've been disbarred or you're put on suspension, you still have to keep up your continuing education during that period of suspension. At the end of the period of suspension, when you are allowed to reactivate your status, you're going to have to show that you maintain continuing education during that time. Representing oneself, participating in rulemaking, limited practice, and special appearances. Firstly, representing oneself. Individuals may appear on their own behalf before the IRS, provided they present satisfactory identification. So if you want to represent yourself, you are certainly allowed to, and you just have to prove that you are yourself. Participation in rulemaking. Individuals may participate in rulemaking as provided by the Administrative Procedure Act. Limited practice. An individual who is not a practitioner may represent a taxpayer before Internal Revenue Service in the following circumstances, provided the individual presents satisfactory identification and proof of his or her authority to represent the taxpayer. An individual may represent a member of his or her immediate family. A regular full-time employee of an individual employer may represent the employer. A general partner or a regular full-time employee of a partnership may represent the partnership. A bona fide officer or a regular full-time employee of a corporation can represent the corporation. A regular full-time employee of a trust, receivership, guardianship, or estate may represent that entity. An officer or a regular employee of a governmental unit, agency, or authority may represent that unit or authority. An individual may represent any individual or entity who is outside of the United States before personnel of the IRS when such representation takes place outside of the United States. And limitations under Section 10.7. An individual who is under suspension or disbarment from practice before the IRS may not engage in limited practice before the IRS. and other limits also apply. You should refer to page 16 of Circular 230 for more information. Section 10.8, Return Preparation and Application of Rules to Other Individuals. Preparing all or substantially all of a tax return. Any individual who, for compensation, prepares or assists with the preparation of all or substantially all of a tax return or claim for refund must have a preparer tax identification number. Except as otherwise prescribed in forms, instructions, or other appropriate guidance, an individual must be an attorney, CPA, enrolled agent, or RTRP in order to be eligible to get a preparer tax ID number. And as we've been repeatedly saying, all of that RTRP stuff is on hold and was being delayed anyway before the enjoinment. Preparing a tax return and furnishing information. Any individual may, for compensation, prepare or assist with the preparation of a tax return or a claim for refund, provided that individual prepares less than substantially all of the tax return or claim for refund, and may appear as a witness for the taxpayer before the IRS, or may furnish information at the request of the IRS or any of its officers or employees. This particular first bullet point right here, that you can assist with the preparation of a tax return or a claim for refund, provided you prepare less than substantially all of the tax return or claim for refund. One of the things I have noticed is that the IRS has a list of forms for which you are required to have a PTIN. So if you are preparing a form for which you are required to have a PTIN, I'm just wondering how you would complete that without being paid to assist with the preparation of a form. So the IRS is saying it's okay to prepare only a form and not sign the form and even get paid for it, but at the same time, you're still supposed to have a PTIN if you're even preparing a form that is a part of the 1040. So this is kind of an open-ended one that I feel needs more clarification. Application of rules to other individuals. Any individual who, for compensation, prepares or assists in the preparation of all or a substantial portion of a document pertaining to any taxpayer's liability for submission to the IRS is subject to the duties and restrictions relating to practice in Subpart B and to the sanctions for violation of the regulations in Subpart C. Unless otherwise a practitioner, however, an individual may not, for compensation, prepare or assist in the preparation of all or substantially all of a tax return or claim for refund, signed returns, or claims for refund. Continuing education providers and continuing education programs. This information that I'm about to relay to you is relevant if you would like to become a provider of CPE. It is also relevant to you if you are obtaining CPE, because as an enrolled agent or an enrolled preparer, if the rules for CE come back under IRS, you have to get your CE from a qualified provider. If you are an attorney or a CPA, you are also, in most cases, most states do have requirements for providers. Most states actually have a requirement that the provider meet NASBA requirements or AICPA requirements. Some require registration with NASBA. Some go further and require QAS for self-study courses. And there are a handful of states that don't have much in the way of requirement at all and leave it up to the CPA, for example, to determine whether the program meets sufficient or adequate requirements. But IRS is very specific about what its requirements are, and that's what we're going to talk about next. Firstly, with respect to continuing education providers. In general, continuing education providers are those responsible for presenting continuing education programs. A continuing education provider must be an accredited educational institution or recognized for continuing education purposes by the licensing body of any state, territory, or possession of the United States, including a Commonwealth or the District of Columbia, or be recognized and approved by a qualifying organization as a provider of continuing education on subject matters within Section 10.6 of this part, be recognized by the IRS as a professional organization, society, or business whose programs include offering continuing professional education opportunities in subject matters within the scope of Section 10.6F. The IRS may, at its discretion, identify a professional, organization, society, or business entity that maintains minimum educational standards comparable to those set forth in this part as a qualifying organization for purposes of this part in appropriate forms, instructions, and other guidance. Currently, there's only one organization that the IRS has approved as an approver of providers. So if you are not an accredited educational institution or you are not recognized by the CE body of any state, or you are not recognized and approved by a qualifying organization, then you're basically out of luck as far as the IRS is concerned. And if you would like to get approved by a licensing organization, you're going to have to do so through your state and get recognized at the state level, or you're going to have to go to NASBA, which is the National Association of the State Boards of Accountancy. If you're a CPA, you're probably really familiar with who NASBA is, and I'll give a little bit of an explanation of what NASBA is about. All of the CPAs in the country are licensed through their states. Attorneys, the same thing. There's no national body that oversees CPAs or attorneys. It's all at the state level. Compared to enrolled agents that are regulated by the IRS and are recognized nationally by the IRS. So if you become an enrolled agent, say in the state of Wisconsin, and you move to Florida, you're still an enrolled agent in the state of Florida because it isn't a state level thing. But if you happen to be a CPA in the state of Illinois and then you move to California, is California going to recognize you as a CPA? Probably you're going to have to jump through some hoops and get registered in the state of California and meet California requirements, whatever they are. So how does a CPA or an attorney go about finding an approved provider? Well, each CPA is responsible for knowing their own state's requirements for CPE. Some states, for example, Washington, are pretty easy. You go to Washington State and look up the rules for CPAs in the state of Washington, and Washington says, if you're a CPA and you attend a program that you as a CPA deems assists you in your work as a CPA, be it accounting or tax or whatever, if you believe it's a good quality program, we're not going to dispute that. We've looked into it in the past and we found that there's really not a need to be more specific than that. And then you come to other states like the state of Oregon, where I'm located, that are very, very strict. In other words, well, not so strict actually. On the issue of self-study programs, the state of Oregon is very strict. It requires QAS, and if the program is not QAS, which is a higher level of credential offered through NASBA, then the state won't recognize it. And many states require NASBA, approve the course. And so NASBA is the National Association of the State Boards of Accountancy, and it's basically a private organization that other boards of accountancy from around the state go to and say, if you meet NASBA's requirements, we will accept CPE provided by a provider. So if a provider is approved by NASBA, most states will accept CPE from that provider. Some states require more than NASBA requirements. If you meet the specifications, they will approve you without actually having you approved by NASBA. And other states will say you actually have to have been approved by NASBA and have a NASBA number before we'll recognize you. And some states don't require any of that. So we often get inquiries to Pacific Northwest Tax School, is your school approved by our state? Well, the answer is most states don't approve schools at all. There is an exception for New York and Texas. They actually approve sponsors, and the sponsor must be approved by those states. But most states don't approve sponsors. They instead say, if the sponsor is approved by NASBA, then typically we'll accept them. In the case of self-study, some states require QAS, which is a higher level of authority provided through NASBA. So IRS is essentially following most state boards of accountancy in this regard and saying, we will accept CPE from a sponsor who is approved by NASBA. But at this point, they're not authorizing any other organization other than NASBA to approve schools, with the exception of schools that are accredited as educational institutions, for example, colleges and universities, or schools that have some other state credential that has been awarded to them. And an example of that would be CTEC, which is the California Tax Education Council in California. That particular group authorizes schools to provide, or sponsors of education to provide, continuing education. It has a lengthy application process that you have to go through. And if you've got CTEC approval, then the IRS will allow you to apply for IRS approval. And if you apply for IRS approval, you have to do so online through Kinsail, K-I-N-S-A-I-L. This is the link to that organization. You have to pay a $419 fee to Kinsail annually as an education provider, and that would be on top of and in addition to any other fees that the organization might have to be paying to a state agency or to NASBA. So for example, Pacific Northwest Tax School pays an annual fee for being a licensed school in the state of Oregon. It pays another fee every 3 years to the state of California. It pays an annual fee to NASBA, and on top of it all, it pays another annual fee to the IRS. So being a qualified sponsor can get expensive, and it's probably not the domain of an individual who just wants to teach 1 or 2 classes a year. That individual would be best off associating themselves with an organization who already has that approval rather than trying to get it in their own name. Continuing education provider numbers. A continuing education provider is required to obtain a continuing education provider number and pay any applicable user fee. When you go online and apply for approval through Kinsale on that site, the provider, once they are approved, is issued a number, and the IRS requires that all enrolled agents and RTRPs who obtain CE from a provider who has a number issued through Kinsale. And to get that number, of course, you have to pay the fee and fill out the application form. A continuing education provider must maintain its status by filing the renewal form and paying the fee annually. A continuing education provider must ensure that the qualifying continuing education program complies with all of the following requirements. The programs must be developed by individuals who are qualified in the subject matter. The program subject matter must be current. Instructors, discussion leaders, and speakers must be qualified with respect to the program content. Programs must include some means for evaluation of the technical content and presentation to be evaluated. That's actually a NASBA requirement as well, and essentially what it says is at the end of every course, you need to be provided with an opportunity to take a survey about the course and to provide feedback to the sponsor of that education as to the quality of your educational experience. NASBA actually has specific requirements about the types of questions that must be included. Certificates of completion bearing a current qualified continuing education program number issued by the IRS must be provided to the participant who successfully completes the program. And what that's saying is that in addition to the sponsor identification number, every course approved for delivery and accepted by IRS must have a corresponding number. The dilemma that we run across as a school is that CTEC requires every course have a number, the IRS requires every course have a number, NASBA requires every sponsor have a number, CTEC requires every sponsor have a number, IRS requires every sponsor have a number. The State Board of Public Accountancy for Texas and for New York both require sponsor ID numbers. So by the time a sponsor like our school issues a certificate of completion, you're going to see it just has sponsor number, course number over and over again, and it's all to meet the requirements of each individual approving entity. And of course, none of the entities share anything in common. We're not allowed to pick our own number and use that number for everyone. Every organization that approves us issues us a separate number. So there's a lot of overlap and duplication there that is arduous. Records must be maintained by the continuing education provider to verify the participants who attended and completed the program for a period of 4 years following completion of the program. In the case of continuous conferences, conventions, and the like, records must be maintained to verify completion of the program and attendance by each participant at each segment of the program. And here is a message from the IRS regarding certificates of completion, and this came out a year ago, and the IRS asked through Kinsale for us to provide you with this information. That is, us as a school providing you as attendees information about CE. Recently, the IRS has received a number of certificates of completion directly from tax preparers. Please assist us in communicating to preparers attending your programs that they do not need to submit their certificates of completion to the IRS because you, the IRS-approved CE provider, are responsible for submitting that information on their behalf. Even though preparers don't have to submit their certificates to the IRS, per Circular 230, registered tax return preparers, EAs, and enrolled retirement plan agents must retain their records of continuing education for 4 years. Thank you very much. Just as an added note on this, the IRS system of recording CE is that those of you who are in attendance in today's class, or any class that has been approved by the IRS, that your attendance has to be monitored by the school. So we're monitoring who's in attendance at today's class. You had to register under your name. You had to provide your PTIN. And once you've done that and you've passed the password test at the end of the day, that will be our system of verifying that you actually were in attendance at today's class. And once we're able to show that you were in attendance at today's class, we are going to upload into Kinsale the fact that you attended. We're going to provide the IRS with your name, your PTIN, the number of hours of CE you obtained, and the category of CE. Was it ethics or was it general tax law? And that information will be uploaded by us to IRS. CTEC in California has a similar system where when a student or an attendee in one of our programs completes a program, we have to upload that information into CTEC. CTEC also does not want to collect pieces of paper or have people mail that in. Other than that, I'm not aware of any association that has automatic upload by the CE provider. If you are a CPA and you are required to submit evidence of CE to your home state board of accountancy, there's not going to be an upload coming from our school to your state board of accountancy. It's not done at that level, nor is it done at the NASBA level. I think NASBA has some kind of a system in place where CE sponsors can provide that information, but it's not a mandatory thing, and it's certainly not universally used by boards of accountancy. We're not utilizing it. It's just one more thing to deal with that certainly at our level we're not yet doing. So individually, CPAs and attorneys are required to maintain their own records and submit those records to their state board of accountancy if so required by their state board of accountancy. So again, it's only the IRS and CTEC that have the uploads coming from the school, and certainly licensed tax preparers and consultants in the state of Oregon are required to maintain their records and hand complete a form that they mail into the state each year verifying that they have the correct amount of CE. Program numbers, I already mentioned that every course you complete that is approved by the IRS is given a program number, and the program number must appear on the certificate of completion, and it should also appear in the advertising literature. So when you visit Pacific Northwest Tax School's site, just as an example, and you look at the description of the course, we provide the program number for the course for IRS, we provide it for CTEC, we provide the sponsor ID number for all of the agencies that require that we have a number, and that should appear, and you should verify that any sponsor that you want to get education from has those numbers as evidence of the fact that the education you get from them will be qualified education. The IRS has identified or defined what an update program is. If you are an RTRP, there is a requirement that you get 3 hours of update law every year. An update program may use the same number as the program subject to the update. An update program is a program that instructs on a change of existing law occurring within 1 year of the update program offering. The qualifying education program subject to the update must have been offered within 2-year time frame period prior to the change in existing law. And a change in existing law means the effective date of the statute or regulation or date of entry of judicial decision that is the subject of the update. Failure to comply, the IRS will notify a continuing education provider who fails to meet compliance requirements and will provide the continuing education provider with an opportunity to furnish requested information in writing relating to a matter within 60 days of the date of notice. The continuing education provider may, within 30 days after receipt of a notice of denial, file a written protest as prescribed by the Internal Revenue Service. And now we're going to move on to duties. Information to be furnished to the Internal Revenue Service. Practitioners must promptly submit records or information requested by officers or employees of the IRS, and a practitioner may be exempted from these rules if he or she believes in good faith and on reasonable grounds that the information requested is privileged and that request is of doubtful legality. Tax practitioner is not in possession of records. Where IRS requests records from a practitioner and the practitioner does not have possession of the records, the practitioner must promptly notify the requesting Internal Revenue Service officer or employee and provide any information that he or she has regarding the identity of any person the practitioner believes may have possession or control of the requested records or information, and make reasonable inquiry of his or her client regarding the identity of the person who has possession or control of the requested records. The practitioner is not required to make inquiry of any other person or to independently verify information provided by the practitioner's client regarding the identity of these persons. So essentially, if IRS has decided to audit your client, they may send you a notice saying, we're reviewing or auditing a return you prepared for this particular client, and we want to see all of the backup documentation you used in the preparation of this return, and you would be required to turn that over. If you used a P&L and then you returned that P&L to your client without retaining a copy of it, which would be not the smartest move on your part, but if you did that, then you would need to notify the IRS that you no longer had the supporting documentation because you had returned it to your client. Now, there's a little bit of an issue that we deal with in tax preparation world. I talk to CPAs who photocopy every single piece of paper that ever comes across their desk. They either make a paper copy of it or they scan it and store it in their records. And if every preparer out there copied every single document that was ever placed in front of them, I can't even fathom the amount of paperwork that would be. And certainly within our firm, preparing 2,000 roughly returns every tax season, the amount of paperwork we deal with is overwhelming. And so we're pretty selective about what we retain copies of. We certainly do retain copies of P&Ls, and if we get a general journal or a general ledger, we're going to keep copies of that. We keep copies of the W-2s and the 1099s, but we don't go through and make photocopies of 100-page long brokerage account statements. We return those to the clients. And, every tax office is going to have its own standards and what it deems to be appropriate for that. We're pretty much interested in maintaining enough records to really support the entries we made on a tax return, and we may or may not copy an entire document, maybe just the front page of it. But whatever you have, if the IRS asks you for it, you need to turn it over. And if it's your policy to return most original documents to your client and not make copies of them, then you would need to notify the IRS that the copy was returned to the client. And if the client doesn't have it, then ask the client who might have it, but you're not required to do any more work than that. Interference with lawful requests for records, that a practitioner may not interfere with any proper and lawful effort of the IRS or its employees to obtain any record or information unless the practitioner believes in good faith and on reasonable grounds that the record or information is privileged. Now, this has nothing to do with privilege, but I can tell you that the IRS auditor seems to come along and ask for documentation and information at the worst possible time, around April 5th. My client will get some letter from IRS that they need something, or I'll get a letter from IRS that they need something, and it's just like, good grief, I'm in the middle of tax season. Am I supposed to drop everything I'm doing for this issue? And the answer is the IRS does want you to drop what you're doing and get information to them, but they are somewhat reasonable. If you give the auditor a phone call and say, hey, I'm buried, it's going to be a good 30 days before I can get to this, the auditor's probably going to say that's fine. But if you put it off for 3-4 months, that's probably not going to fly. Knowledge of client's omission. A practitioner who is retained by a client to assist or represent that client with respect to a matter administered by the IRS must promptly inform the client of any errors or omissions that the practitioner finds with regard to preparation of any return or document that has been submitted to the IRS. The practitioner must also advise the client of the consequences of the errors, omissions, or noncompliance. So what this is saying is you have a new client sitting in front of you, or maybe even a current client who you've worked on in the past, but you're reviewing a tax document and you find that there's an error on it. Ethics requirements are that you must notify the client of the error. You cannot see an error on a client's return and remain silent on it. And that can be a dilemma if the error is your own, because there's nothing worse than admitting to your own mistakes, and there's the risk you'll lose the client because you've just told them, hey, last year I goofed up, or some other person in my firm goofed up on your tax return last year. There is an error, and this is the consequences of the error. You're not allowed to hide that, regardless of how your client is going to react. Now, if it wasn't your error and it wasn't your firm's error, it's much easier to point it out, but the ease of pointing it out and the reaction of how your client will behave when they find out about that error doesn't play in. The law is that you have to notify them. Diligence as to accuracy. A practitioner must exercise due diligence when performing the following duties: preparing or assisting in preparing, approving, and filing returns, documents, affidavits, and other papers relating to IRS matters; determining the correctness of oral or written representations made by him or her to the Department of Treasury, and determining the correctness of oral or written representations made by the practitioner to clients with reference to any matter administered by the IRS. It is considered due diligence for the practitioner to rely on the work product of another person if the practitioner has used reasonable care in engaging, supervising, training, and evaluating that person. And following is some information in italics here. You can see up above it's not in italics. It's basically coming straight out of Circular 230. And underneath I've got some other information that comes from alternative sources, just kind of as an adjunct or an explanation of that. And so IRS says you have to exercise due diligence, and you are exercising due diligence if you are employing a person who works for you. IRS says you are exercising due diligence if you employ others to do work for you, as long as you can show that they've received adequate training and supervision. And here is an example. It is common for CPAs, enrolled agents, and unenrolled tax preparers to employ tax preparers on staff who are responsible for collecting and entering tax return information into a tax return. The IRS requires a practitioner to exercise due diligence by ensuring that reasonable care is used in hiring and training the employees. The IRS sometimes issues more detailed regulations and guidance for specific tax preparation situations. An example is the earned income credit due diligence. And every time I go to the IRS website to see what IRS has now done for earned income credit due diligence, it seems to be getting to be a longer and longer list. But IRS is saying you are only exercising due diligence if you meet all of the requirements in these 4 parts. That is, you complete the eligibility checklist, you maintain a record of how you compute the credit, and then there's this knowledge requirement, which is pretty interesting. You must know the law and use your knowledge of the law to ensure you are asking your client the right questions to get all relevant facts. That is, determine if your client is entitled to the earned income credit. Well, this knowledge requirement, even though it's spelled out for EITC, probably is there for all other tax matters as well. So if you're making a determination about whether your client is entitled to the child tax credit or the particular itemized deduction on their tax return or a particular business expense, you're supposed to be knowledgeable about the law. You must also take into account what your client says and what you know about your client. You must not know or have reason to know of any information used to determine your client's eligibility for and the amount of the EITC is incorrect. You must make additional inquiries if a reasonable and well-informed tax return preparer would know that the information is incomplete, inconsistent, or incorrect. So maybe you have first-hand knowledge that your tax client is married, but they're telling you that they're unmarried. And you're going, really? Did you get a divorce? I didn't know. When did that happen? If you know your client's married, or in a previous situation they've described themselves as married, that means you need to be asking questions. And if they are married and they're saying they're unmarried, why are they saying that? Is it that they separated, or is it that they're in the pending divorce but they're not divorced yet, or are they just flat out lying? Those are determinations that you need to make. You must document any additional questions you ask and your client's answer at the time of the interview. Well, the IRS is saying when it regards to earned income credit, you have to ask very specific questions. And any question you ask, you need to write it down and you need to write down your client's response to that question. Quite frankly, that is good due diligence no matter what question you ask your client. And in our firm, we do have an interview sheet that we require all of our preparers to hand complete. And then at the end, we turn it around and have our clients sign off on it, because we just feel we can't ask enough questions or maintain enough records. And why do I say that? Clients are pretty happy at the tax preparation point. Well, most of the time. Some of them think going to the tax preparer is like going to the dentist. It's the worst day of the year for them. They're under so much anxiety. But for a lot of people, going to see the tax preparer is a professional experience, and they even look forward to it. I have clients who've been coming to me for 20 years who I really feel very friendly with. I'm interested in them. I've watched their children go up. I've seen them retire from careers. I've known them a very long time. And I'm sure all of us can relate to individual clients that we have. And then we also have other clients who we don't know them quite so intimately, but we've been doing their tax return professionally for many years, and we probably think our clients think we're pretty good, or at least we hope they do. But when the day comes that a client gets audited, that client whom we thought was a good friend to us or engaged in professional conduct towards us may show a completely different face. And if they're going to turn on anyone in the audit, it's going to be the preparer who did the return. And if they blame anyone for any inaccuracies on the return, odds are they're going to blame the tax preparer. Now, this isn't always a universal truth. Plenty of times clients are fully aware of the fact that they're fudging numbers when they are working with their tax preparer. And when they get that audit letter, they're fully accountable for that fact and walk into the IRS with their head down and they accept the slap on the wrist. And they may or may not even inform their preparer that the audit happened. But there is that type of person who will, in the interview, kind of wash over facts and be blasé about facts and even try and put facts into the preparer's mouth. Well, this year I'm the head of the household, and the preparer says, okay, you're head of household, and puts that down on the return. And then the IRS auditor says, you don't qualify for head of household, and the client says, well, my preparer told me I was head of household. That's what they put on the return. And so head of household is a really good example because it's one of the most frequent errors that the IRS finds on a return. And it's not uncommon for, of course, a tax client to say the preparer gave them that status. And the tax preparer should never award head of household status without asking questions necessary to establish that that status is available. So with that, let's move past the IRS EITC ethics and on to the next topic, which is prompt dispositions of pending matters. A practitioner may not unreasonably delay the prompt disposition of matters before the IRS. And with that, I'm saying, hey, the IRS has sent you a request for information. You need to give it in a prompt period of time. You can be reasonable about requests for additional time, but you can't be unnecessarily impeding progress. Section 10.24, assistance from or to disbarred or suspended persons. A practitioner may not accept assistance from any person who is under disbarment or suspension from practice before the IRS if the assistance relates to matters constituting practice before the IRS, or accept assistance from any former government employee where federal law would be violated. So what this is saying is, let's just suppose you own a tax service and you employ some tax preparers, and one of those tax preparers was an enrolled agent, but they're under disbarment. You're not allowed to employ that person. Even if you're not an enrolled agent, you're still governed by Circular 230 because you own a tax service that prepares tax returns. If you work in an office where you see a disbarred person is working, they lost their EA credential, but they're still coming in and doing work, that should cause you serious concern, and perhaps maybe you should be moving on. So being associated in your professional capacity, people who are disbarred, is not a good idea. Practice by former government employees, their partners, and their associates. Former government employees and their partners are subject to additional rules described in this section. If you are a former government employee, you should refer to this section and follow all rules contained in it. A practitioner may not act as a notary or certify papers with respect to any matter on which the tax practitioner is interested. So in other words, if you're required to submit a documentation to the IRS on your own behalf and that document needs to be notarized, you can't notarize it yourself. You're going to have to go get another notary to notarize a document. Fees. In general, a practitioner may not charge an unconscionable fee in connection with any matter before the IRS. And contingent fees. A preparer may not charge a contingent fee for services rendered with any matter before the IRS except where the contingency fee relates to an IRS examination of or challenge to an original tax return or an amended return filed within 120 days of IRS notification to the taxpayer of examination or challenge to the original return. The contingency fee is for services in connection with a claim for credit or refund, solely in connection with statutory interest or penalties, or the contingency fee is in connection with judicial proceeding arising under the Internal Revenue Code. So essentially what this section is saying is it's illegal to prepare a tax return for a person and base your fee on the size of the refund or the amount of tax that you've saved them. You need to have a fee schedule that is based on other criteria. For example, many firms charge based on the hour. Our fee is $150 an hour, our fee is $200 an hour, our fee is $250 an hour. That's okay. Another way of charging fees is form-based. You have a particular fee that you charge for each and every individual form that you prepare or each individual line entry that you do on a return. That, too, is an acceptable method of assessing fees. But to charge a fee based on a client's refund or the amount of tax that you saved them is illegal. There's also another definition of what constitutes a contingency fee, and if you meet this definition of contingency fee, that also is not allowed. Contingent fee includes a fee that is based on a percentage of the refund reported on a return, a percentage of the taxes saved, or that is otherwise depends on a specific result attained. A contingency fee also includes any fee arrangement in which the practitioner will reimburse the client for all or a portion of the client's fee in the event that a position taken on a tax return or other filing is challenged by the IRS or is not sustained. So you would not be allowed to say, hey, I'm going to prepare your tax return and then we're going to put a few deductions on here. These are kind of a gray area. They could hold up in an audit, but your odds of an audit are pretty small. So tell you what, if you never get audited, the fee that I collect from you, I'm going to keep it. But, if you get audited and the IRS auditor throws those deductions out and says you're not allowed them, I'm going to refund your fee. So we're all even, and the worst that's going to happen to you is you're going to have to pay some interest, but the odds of the audit are pretty small. That would definitely be a no-no. That would be out of compliance with ethics rules. It would be out of compliance with the contingent fee rule as well. Matter before the IRS includes tax planning and advice, preparing or filing or assisting in the preparing or filing of returns or claims for refund, preparing and filing documents, correspondence, and communicating with the IRS, or rendering written advice with respect to any entity, transaction, plan, or arrangement, and representing a client at conferences, hearings, and meetings. Return of client's records. In general, a practitioner must, at the request of a client, promptly return any and all records of the client that are necessary for that client to comply with his or her federal tax obligations. A practitioner may retain copies of the records returned to a client. The existence of a dispute over fees generally does not relieve the practitioner of his or her responsibility under this section. Nevertheless, if an applicable state law allows or permits the retention of a client's records by a practitioner in the case of a dispute over fees for services rendered, the practitioner need only return those records that must be attached to the taxpayer's return, such as W-2s. The practitioner, however, must provide the client with reasonable access to review and copy any additional records of the client retained by the practitioner under state law that are necessary for the client to comply with his or her federal tax obligations. Well, I've said it before and I'll say it again. I'm not aware of any state that specifically allows retention of client records where there is a dispute over fees. I am aware of certain states, including Oregon, where it is specifically not allowed to retain client records. And if a client requests those records back, the law requires that you give them back in most states. So that's the safe thing to do. It may not seem the fair thing to do. If you've done all the work and you've prepared a tax return and your client owes you money, you still have to return those records, and you can't retain them to force them to pay your fees. You could go after them under other avenues, for example, taking them to small claims court to collect there. And of course, most firms have probably been in a situation where they've had to do that, but you can't just withhold the records and refuse to return them. Conflicting interest. A practitioner shall not represent a client in his or her practice before the IRS if the representation involves a conflict of interest. A conflict of interest exists if representing one client will be directly adverse to serving another client, or there is a significant risk that responsibilities to one or more clients will adversely affect the practitioner's ability to service another client, or the interests of the practitioner are adverse to the interests of one or more clients. There is an exception to this rule. Even if a conflict of interest exists, a practitioner can still represent a client if the practitioner reasonably believes that he or she is able to provide competent and diligent representation to each affected client, that the representation is not prohibited by state law or federal law, and each affected client provides informed consent and signs a written waiver within 30 days. Copies of written consents must be maintained for at least 36 months. I'm going to give you some poll questions to work on for discussion. Crater Lake. C-R-A-T-E-R-L-A-K-E. Crater Lake. There were 3 different poll questions I put up, and we'll just take these in turn, beginning with number 5. Selena, a CPA, has prepared a tax return for her client that includes a loss on a publicly traded partnership that is being reported on a K-1. Selena observes that her software is allowing a loss to be claimed and is unsure of whether or not it should be allowed. What should she do? This is actually a topic of passive activity loss limits and rental income. And one of the observations I've made over time is a lot of tax preparers are completely clueless about passive activity loss limits. And they'll get a K-1, it has a negative number on it, they'll enter it into the tax software, and just whatever they do in that tax software, the software will or will not allow the loss, without regard to them putting any thought into whether the loss is allowed or not allowed. And of course, a competent ethical tax preparer should actually understand the K-1, what they're reading on it, and the type of questions that should be asked relating to a loss on a K-1. And in case of a publicly traded partnership, losses are only allowed to the extent of income from that same publicly traded partnership, including sale of interest in that partnership. And so there's a very specific rule in play about what that CPA should be doing, and unsure, scratching her head means she needs to figure it out. And if she just proceeds without figuring it out, then that would be a violation of ethics rules that require her to exercise due diligence. Next one, Fred. An unenrolled tax preparer works with a franchise tax office. He also runs his own Amway business, and Fred routinely invites tax clients to come to his Amway meetings. Is there anything in Circular 230 or other regulations that addresses this practice? Well, I'm of the opinion that the answer is yes, and we haven't gotten to it yet in our course, but we are shortly, as we're trying to rush through the last hour, going to come to Section 7216. It's not a part of Circular 230. It's a separate section that surrounds disclosure or use of information by preparers of returns. And preparers are authorized to use information that they obtain in the preparation of a tax return for the preparation of the tax return. The question is it appropriate for a preparer who uses information from a tax return to contact a client about an Amway meeting? Well, you could say, well, the client is sitting across from the desk and we're having a conversation, and the conversation surrounds the preparer and what he does in his free time, which is Amway. And, if the client says, oh, yeah, I'm interested in Amway, and the preparer says, well, you can come to a meeting, that would probably be all right. But if the preparer is, evaluating information contained on the tax returns of his clients to establish whether or not they might be the type of person that would be a good client for their Amway product, that's probably a misuse of the information. At least in my opinion, it is. How it would be deemed to be treated in a court of law or by the IRS is another issue. We all have different standards of what we think is ethical. But certainly if I had a preparer working for me who was inviting my clients to his Amway meetings, he'd be out the door in a heartbeat. Completely inappropriate conduct as far as I'm concerned, unprofessional, whether it's legal or not, and I quite frankly question the legality of it. And then finally, the last problem of the day, problem number 7. Ron Hill is an enrolled agent. For the past 10 years, he has prepared tax returns for a married couple named Jack and Jill Hill. Ron is sitting down with Jack to prepare his most recent year's tax return and learns that Jack and Jill are separated and getting a divorce. Jack states that Jill will be coming in later to prepare her separate return. What action, if any, is required of Ron in this situation? Well, this is a rather appropriate question to ask immediately after we talked about the conflict of interest provision that the IRS has in Circular 230. And I do consider this to be a conflict of interest. The appropriate thing to do would be to say to Ron, you have both been my clients in the past, and I'm happy to continue working with both of you again now that you're getting a divorce. However, the divorce means that there are adverse interests between the two of you, and I have to disclose the fact that there's an adverse interest. I believe that I can be indifferent and impartial as a tax preparer, and that I can be objective as a tax preparer, and that I can do a good job of preparing both your tax returns. But I do need to disclose to you the fact that there is a conflict of interest, and I need your written consent to move forward with this. Now, earlier this past tax season, I had a situation that was similar, but a little bit different than this. I had a new client come to me. She's never been my client before, and she arrived and she said, yeah, I'm going through a divorce. I've been in a partnership arrangement with my husband for several years. We have a business that we do together, and we've been filing as joint ventures with individual Schedule Cs on our tax return. And because we've been doing this business together for so long, I'm hoping that you can do my husband's return as well as my own return, but I don't want to file with him. What do you have to say about that? And my answer was, well, you could file jointly or you can file separately. Here are the possible outcomes if you file joint. You would have a bigger refund, but on the other hand, you could be on the hook for any tax liability that he has. And so I wouldn't really recommend it in a divorce situation like this, especially if his finances are a little uncertain. You're probably better off filing separately. In terms of representing you and representing him, you've come to me first. You are my tax client. And I'm willing to prepare his tax return, but now I have to inform you that there is a conflict of interest if I do so. And I'm going to need to get written consent from the both of you to proceed. And so I got that written consent and I proceeded and did the return. So that type of action is necessary. And certainly what you should never do is prepare a tax return for a client in a divorce situation and then speak to the other spouse or former ex-spouse about one another. That would be definitely a violation of ethics and discretion and certainly should not be done. I thought I should also mention that it is not uncommon to be in a situation where you've got partners in a partnership. Perhaps you are preparing the partnership return and you've also been preparing the individual returns. That partnership is coming to an end. There's some hostility there. That would be another situation where I would recommend you get written consent before proceeding forward. The next topic of the day is solicitation, advertising and solicitation requirements. And this is kind of a little bit on the avenue of the Amway guy as well. But let's see what we have to learn about here. A practitioner may not, with respect to any IRS matter, in any way use or participate in the use of any form of public communication or private solicitation containing a false, fraudulent, or coercive statement or claim, or misleading or deceptive statement or claim. Let me think about Amway a little. Most Amway businesses lose money. So if you're sitting in a tax interview with a client and you're preparing their tax return and you're encouraging them to come to your Amway meeting and sign up with Amway because they can make all this money, I might consider that to be misleading advertisement, even though it has nothing to do with their tax return. And then, of course, we get into the issue of misuse of information and so forth. So lots to say about that Amway stuff. Title: Enrolled agents, enrolled retirement plan agents, and registered tax return preparers, in describing their professional designation, may not use the term certified or imply an employer-employee relationship with the IRS. Acceptable enrolled agent designation can include enrolled to represent taxpayers before the IRS, or enrolled to practice before the IRS, or admitted to practice before the IRS. That would be a statement that you could actually print on your business card or put on your website, put on your wall, whatever you want to do to advertise or promote yourself. Those would be acceptable standards. Enrolled agents have a similar designation. And for registered tax return preparers, if you currently hold the designation, I haven't seen anything coming out of IRS that says you're not allowed to use it. They've kind of just gone totally silent on the issue. Do you have to hide your certificate? Are you allowed to present your certificate? Are you allowed to call yourself a registered tax return preparer? These are some of the things that the IRS is saying nothing about. But at any rate, the IRS has said in Circular 230 that if you are an RTRP, and I would say you are an RTRP if you're holding the credential, that you can call yourself designated as a registered tax return preparer by the Internal Revenue Service. Now, aside from this, we have state boards of accountancy that license CPAs, and of course CPAs can represent themselves as CPAs if they are in good standing and licensed through their respective bodies. Outside of CPAs and the IRS, there are state registration and licensing of tax preparers, and the following states have tax preparer registration programs. They include California, Maryland, and New York, and of course the state of Oregon, which I've already explained, has licensing. And I've got information in here about what you need to do to become a California registered tax return preparer. In Maryland, you need to become registered with the state of Maryland if you wish to prepare tax returns there. New York requires a registration procedure as well and payment of, I believe, a $100 fee. And then in Oregon, you have to go through some licensing requirements that are listed here. Now, aside from those individual state licensing requirements, there are some other titles that have no bearing at federal or state levels. They're essentially credentials that are made up by either a private organization or a group or association. A few for-profit and non-profit organizations offer titles to tax preparers who either complete a specified program of education and or testing, or who become members of an association by paying a fee and adhering to ethic guidelines set forth by that organization. One of these organizations is the Accredited Tax Return Preparer. This designation is awarded by the Accreditation Council for Taxation and Taxation, or ACAT, and it was established in 1973 as a non-profit independent testing and accrediting monitoring organization. As good as this organization probably is, and as much as the credential may likely mean to anyone who's researched it, it actually holds no status in the eyes of the IRS. And in the eyes of the IRS, you're going to need to be an enrolled agent, a CPA or attorney, or a registered tax return preparer to really be recognized. Also, beware of any group or organization that basically says they're going to certify you as a tax preparer or charter you as a tax preparer. Those, again, are credentials that are basically made up and are meaningless at any legal level. Solicitation. A practitioner may not make, directly or indirectly, an uninvited written or oral solicitation of employment in matters related to the IRS if that solicitation violates federal or state law or other applicable rule. A lawful solicitation made by or on behalf of a practitioner eligible to practice before the IRS must nevertheless clearly identify the solicitation as such, and if applicable, identify the source of the information used in choosing the recipient. So you're at an IRS audit, things are going well, you're kind of buddy-buddy with the IRS auditor there, and you're saying, yeah, I'd like to become an auditor. How do I apply for a job here? Or can I submit an application here? That would be inappropriate conduct. You shouldn't be asking the auditor that question. The IRS, when it does have openings available, publishes those openings, and you would go through the normal procedures to apply to those openings. And when you're applying to those openings, you should clearly identify the opening you're applying to, where it was advertised and how you found out about it. Fee information. A practitioner may publish the availability of a written schedule of fees and disseminate the following fee information: fixed fees for specific routine services, hourly rates, a range of fees for particular services, or a fee charged for initial consultation. Disclosure of client's responsibility for costs. Any statement of fee information concerning matters in which costs may be incurred must include a statement disclosing whether clients will be responsible for such costs. Well, it seems self-evident to me, and probably most of you, that when someone walks in the door of a tax office, they're walking in the doors of a paid service. But oddly enough, over the years, I've run across plenty of clients who somehow seem to think that my company is a branch of the federal government or a state government, and therefore what we do must, of course, be free. Why should they have to pay for it? And so it makes sense, both ethically and for business reasons, to really disclose to the client that you are a paid service and how much you're going to charge for that paid service and when that fee needs to be paid, and get that client to sign off on it, typically in the form of an engagement letter. You're engaging this service. This is how much we charge. This is what we're going to do for you. This is the terms of the engagement. This is what you are required to provide us. This is what we're going to give you in exchange, and have that client sign off on it. And once you've done that, you've done something that really is ethically necessary and business smart. And that way, if a client has any concerns about being able to pay you or how much you charge, that's taken care of right up front. And it's not dealt with at the end when you give them a bill for $500 and they're somehow so shocked because they thought it would be $30 or that it would be free, or they thought it would be $200, whatever price they had in mind. It's just the wrong time to be dealing with that as an argument at the end. It really should be discussed up front and be quite clear. Fee changes. A practitioner may charge no more than the rates published for at least 30 calendar days after the last date on which the schedule of fees was published. And that can be a challenge. If you update your fee schedule every year in January and tax season starts in January, theoretically you can't increase your fees until that schedule has been posted for 30 days. So for that reason, maybe it's a good idea to update your fees each year in December and not wait until the last minute. Communication of fee information. Fee information may be communicated in professional lists, telephone directories, print media, mailings, and electronic mail, facsimile, hand-delivered flyers, radio, television, and any other method. The method chosen, however, must not cause the communication to become untruthful or deceptive. Contacting prospective clients. A practitioner may not persist in attempting to contact a prospective client if the prospective client has made it known to the practitioner that he or she does not desire to be solicited. Broadcast and e-commerce communications. In the case of a radio and television broadcast, the broadcast must be recorded and the practitioner must retain a recording of the actual transmission. Improper associations. A practitioner may not, in matters related to the IRS, assist or accept assistance from any person or entity who, to the knowledge of the practitioner, obtains clients or otherwise practices in a manner that is prohibited under this section. Negotiation of taxpayer refund checks. Practitioners who are income tax preparers may not endorse or otherwise negotiate or cash any refund check issued to the taxpayer. The practitioner may not construe IRS regulations as authorization to practice law. And best practices for tax advisors. Tax advisors should provide clients with the highest quality representation concerning federal tax issues by adhering to best practices in providing advice and in preparing or assisting in the preparation of a submission to the IRS. Tax advisors with responsibility for overseeing a firm's practice of providing tax advice or preparing or assisting in the preparation of submissions to the IRS should take reasonable steps to ensure that the firm's procedures for all members, associates, and employees are consistent with best practices. So what this is saying is if you have people working with you in your firm, especially if they're working under you in your firm, you should have a written set of policies and procedures in place that ensure you are adhering to best practices. For example, in our firm, we have a policy and procedure manual that is 50 to 100 pages long about every element of the tax return, how to schedule an appointment, how to give a price estimate, how to keep a record or give a written price estimate, how to interview the client, how to record information from the client in the interview, how to respond to specific types of statements or inquiries that a client may make of the preparer at the time, how to respond to inquiries over the phone. We're very, very specific about how we want our tax preparers to be communicating with our tax clients because it's just smart business practice, but it's also part of the best practices that the IRS has said that you should be implementing in a firm. So best practices include the following. Communicating clearly with the client regarding the terms of the engagement. For example, the advisor should determine why the client is seeking the advice and how the client expects to use this advice. The preparer and the client should also have a clear understanding regarding the form and scope of the advice or assistance to be rendered. So a client contacts you and says, yeah, I want to know what happens if I sell my house. Well, what kind of a house is it? Why are you selling it? Are you going to sell it at a profit or a loss? Why are you asking me the question? Those would be reasonable questions to ask, because in order to give an appropriate answer to the question, you're going to need to have all of that information. And selling a house that you've owned and occupied for 2 out of the last 5 years as your main home is going to have a different outcome than selling a vacation rental, or selling a rental house that used to be your home, but it's been rented for a period of years now. There's going to be different responses to all of those questions, and it's only appropriate to ask questions necessary to get to the facts. And establishing the facts is something you need to do. You need to determine which facts are relevant, evaluate the reasonableness of any assumptions or representations relating to the applicable law, and arriving at a conclusion supported by law and facts. Advising the client regarding the import of conclusions reached, including, for example, whether a taxpayer may avoid accuracy-related penalties under the Internal Revenue Code if a taxpayer acts in reliance on the advice and acting fairly and with integrity in practice before the IRS. Procedures to ensure best practices for tax advisors. Tax advisors with responsibility for overseeing a firm's practice of providing advice concerning federal tax issues or of preparing or assisting with the preparation of submission to the IRS should take reasonable steps to ensure that the firm's procedures for all members, associations, and employees are consistent with the best practices set forth in paragraph A of this section. And section 10.34, standards with respect to tax returns and documentation, affidavits, and other papers. Firstly, with tax returns, a practitioner may not willfully, recklessly, or through gross incompetence sign a tax return or a claim for refund that the practitioner knows or reasonably should know contains a position that lacks a reasonable basis, is an unreasonable position, or is a willful attempt by the practitioner to understate the liability for tax, or is a reckless or intentional disregard of the rules or other regulations by the tax practitioner. Advise a client to take a position on a tax return or a claim for refund, or prepare a position of a tax return or claim for refund that lacks a reasonable basis, is an unreasonable position, or is a willful attempt by the practitioner to understate the liability for tax, or is a reckless or intentional disregard of rules or regulations by the practitioner. Also, a pattern of conduct is a factor that will be taken into account in determining whether a practitioner acted willfully, recklessly, or through gross incompetence. And if you are engaging in a pattern of behavior, your odds of getting caught are pretty high. If you do something one time, odds are it probably won't ever come back to bite you. But if you get into a regular pattern of doing it, odds are that pattern is going to lead to one of your clients getting audited. One of those clients that gets audited is going to make a comment about you, or they're going to look at the quality of the tax return. That is, the IRS is going to look at the quality of the return that you prepared or was prepared by your firm, and that's going to open up the door for all other kinds of audits on all of the other returns you prepared, and they're eventually going to figure out that there is a pattern. And here is a note on that. Hawkins to flag advisors of clients with successful reasonable cause defense. The Office of Professional Responsibility Director, Karen Hawkins, has said that she has asked appeals officers to consider making a referral to her office when they abate a taxpayer's Section 662 penalty based on a successful reliance on advisor defense, when the underlying adjustment for the position is nevertheless sustained, so that she can investigate the competence of the advisor who issued the opinion relied on by the taxpayer. So what she's saying is, okay, we're in the audit. The tax return is wrong, and it's really wrong. And the taxpayer is blaming their tax preparer and saying, I just did what my tax preparer told me to. And the auditor believes the taxpayer and says, yeah, that seems very incompetent on the part of the preparer. And based on what you're saying, I agree that it's probably the preparer's fault. So I'm not going to penalize you with penalties, but I'm still going to assess the tax. Karen Hawkins is saying if that tax is assessed, but the penalty is waived because of the innocence defense on the part of the taxpayer, then that practitioner information should be forwarded to her office so they can investigate the preparer. Documents, affidavits, and other papers. A practitioner may not advise a client to take a position on a document, affidavit, or other paper submitted to the IRS unless the position is not frivolous. A practitioner may not advise a client to submit a document, affidavit, or other paper to the IRS, the purpose of which is to delay or impede administration of federal tax law that is frivolous, or that contains or omits information in a manner that demonstrates an intentional disregard of a rule or regulation, unless the practitioner also advises the client to submit a document that evidences a good faith challenge to the rule or regulation. Advising clients on potential penalties. A practitioner must inform a client of any penalties that are reasonably likely to apply to the client with respect to a position taken on a return if the practitioner advised the client with respect to the position or the practitioner prepared or signed the tax return. Any document, affidavit, or other paper submitted to the Internal Revenue Service. The practitioner must also inform the client of any opportunity to avoid a penalty by disclosure, if relevant, and of the requirements for adequate disclosure. So there are some situations in the IRS where maybe it isn't quite clear what you need to do. It's questionable. And the IRS says in a situation where you're not quite sure, you can't find supporting evidence for what you want to do, but maybe you can't find supporting evidence the other way either, that would be an opportunity for disclosure, and that you should provide disclosure to the IRS of the questionable item and let the IRS make a determination right then and there based on the disclosure. Relying on information furnished by clients. A practitioner advising a client to take a position on a tax return or preparing or signing a return as a preparer may generally rely in good faith without verification upon information furnished by the client, but may not ignore the implications of information furnished to or actually known by the practitioner, and must make reasonable inquiries if the information as furnished appears to be incorrect, inconsistent with the important fact or another factual assumption, or is incomplete. And here we have another comment on the responsibility for positions and returns. In 2008, regulations eliminated the one preparer per firm rule, under which only the signing preparer was deemed to be responsible for the return's accuracy and liable for any penalties. Current regulations now allow the IRS to also penalize and hold responsible other preparers who were involved in the preparation of that return, even if they didn't sign it. Requirements for covered opinions. A practitioner who provides a covered opinion shall comply with the standards of practice in this section. A covered opinion is written advice by a practitioner concerning one or more federal tax issues arising from transactions that the IRS has determined to be tax avoidance transactions and have been identified by published guidance as listed transactions. And there's a whole section, section 10.35, to read on that if you're interested. Section 10.37, procedures for ensuring compliance. This section requires adherence to procedures that ensure compliance with rules relating to providing covered opinions, and that's a whole huge section that I'm not going into at all. Section 10.38 has to do with establishment of advisory committees. To promote and maintain the public's confidence in tax advisors, the IRS is authorized to establish one or more advisory committees composed of at least 6 individuals authorized to practice before the IRS. Members of an advisory committee must be balanced among those who practice as attorneys, accountants, enrolled agents, enrolled actuaries, enrolled retirement plan agents, and registered tax return preparers. Subsection C, this is a section you are required to be knowledgeable about if you're sitting for the EA exam or the RTRP test, because they're going to ask you questions about it. And quite frankly, if you're a CPA or an attorney and you come under sanction, you need to be familiar with this section because it tells you what you need to do in response to notification from the IRS of a potential sanction. Section 10.50 on sanctions. The Secretary of the Treasury or delegate, after notice and an opportunity for proceeding, may censure, suspend, or disbar any practitioner from practice before the Internal Revenue Service if the practitioner is shown to be incompetent or disreputable, fails to comply with any regulation of this part, or with intent to defraud willingly and knowingly misleads or threatens a client or prospective client. Censure is a public recommend. Incompetence and disreputable conduct. Incompetence and disreputable conduct for which a practitioner may be sanctioned includes, but it is not limited to, conviction of any criminal offense under federal tax law, conviction of any criminal offense involving dishonesty or breach of trust, conviction of any felony under federal or state law, giving false or misleading information, solicitation of employment as prohibited, willfully failing to make a federal tax return, willfully assisting, counseling, encouraging a client or prospective client in violating or suggesting to a client or prospective client to violate any federal tax law, misappropriation of or failure properly to promptly remit funds received from a client for the purpose of payment of taxes. So if your client gives you money so that you can pay their tax debt, you need to get it off immediately. And quite frankly, I never put myself between my client and their money in the IRS at all. If my client needs to mail a check to the IRS, I give them the envelope and I say, go put it in the mailbox. I want nothing to do with being the middleman there. Now, it is possible when a client owes money to set that payment up for a direct debit through their bank account at the time you file the return. I have no issue with that at all because that's something that can be verified. It's all electronic. But when a client hands me a check and expects me to mail it, my policy is no, and the policy of our company is no, specifically because we don't ever want to be accused of not having done that. It's just a procedure issue on my part, but it has to do with this rule right here. Directly or indirectly attempting to influence any officer or employee of the Internal Revenue Service, disbarment or suspension from practice as an attorney, CPA, public accountant, or actuary, knowingly aiding and abetting another person to practice before the Internal Revenue Service during a period of suspension or disbarment, contemptuous conduct in connection with practice before the Internal Revenue Service, including the use of abusive language, making false accusations or statements, knowing them to be false or circulating or publishing malicious or libelous matter, giving a false pattern, or engaging in a pattern of providing incompetent opinions. And then it goes on here to describe what that is. Reckless conduct is a highly unreasonable omission or misrepresentation involving an extreme departure from the standards of ordinary care that a practitioner should observe under the circumstances. Or a pattern of conduct is a factor that will be taken into account in determining whether a practitioner acted knowingly, recklessly, or through gross incompetence. And gross incompetence includes conduct that reflects gross indifference, preparation which is grossly inadequate under the circumstances, and a consistent failure to perform obligations to the client. I would say in our very first group discussion, if you took that P&L and filed a tax return based on that P&L, that would be grossly incompetent. That's my opinion. Willfully failing to sign a tax return prepared by the practitioner when the practitioner is required to do so. Willfully disclosing or otherwise using a tax return or tax return information in a manner not authorized by the Internal Revenue Code. Willfully failing to file on magnetic or other electronic media a tax return prepared by the practitioner when the practitioner is required to do so by federal law. And clearly, we currently have an e-file mandate where if our firm prepares 11 or more individual or 1041 series returns in a year, we're required to e-file. And so I would be saying, we're not allowed to not e-file unless we have a really good reason and have applied for a waiver. Willfully preparing all or substantially all or signing a tax return or a claim for refund when the practitioner does not possess a current or otherwise valid tax ID number or PTIN. Willfully representing a taxpayer before an officer or employee of the Internal Revenue Service unless that practitioner is authorized to do so. And then we have Subpart D's rules applicable to disciplinary proceedings. This part of the course highlights certain parts of Section D or Subpart D that practitioners should be aware of, but it is no way or means a complete discussion. Subpart D covers rules and procedures that are applicable whenever it is determined that a practitioner or employer firm or entity, if applicable, violated any provision of the laws governing practice before the IRS. And it begins with the institution of a proceeding. If it's determined that you're in violation, there will be an institution of a proceeding. Whenever it is determined that a practitioner, employer, or firm violated any provision of the laws, they're going to be subject to sanctions. And except as provided in Section 10.82, a proceeding will not be instituted under this section unless the proposed respondent previously has been advised in writing of the law, facts, and conduct warranting such action, and has been accorded an opportunity to dispute the facts, assert additional facts, and make arguments, including an explanation or a description of mitigating circumstances. So it's never going to be the case that you're going to get sanctioned without being offered an opportunity to respond to an accusation of improper misconduct. The accusation is going to be submitted to you in writing, and you're going to have an opportunity to respond to it. Conferences. In general, the commissioner or delegate may confer with a practitioner, employer, firm, or entity, or an appraiser concerning allegations of misconduct, irrespective of whether a proceeding has been instituted. Voluntary sanction. In lieu of a proceeding being instituted or continued, a practitioner or appraiser may offer a consent to be sanctioned. So it could be they're threatening to sanction you, and you say, well, they're going to catch me. Why go through the misery? Just let them sanction me, and that could be the end of it. That's okay. Contents of a complaint. Charges. When a complaint is filed, it has to have certain content, and among those are the charges. The complaint must name the respondent and provide a clear and concise description of the facts and the law that constitute the basis for the proceeding, and it must be signed by an authorized representative of the IRS. A complaint is sufficient if it fairly informs the respondent of the charges brought so that the respondent is able to prepare a defense. Specification of sanction. A complaint must specify the sanction sought against the practitioner or appraiser. If the sanction sought is a suspension, the duration of the suspension sought must be specified. Demand for answer. The respondent must be notified in the complaint or in a separate paper attached to the complaint of the time for answering the complaint, which may not be less than 30 days from the date of the service of the complaint. The name and address of the administrative law judge to whom the answer must be filed. The name and address of the person representing the IRS to whom a copy of the answer must be served, and that a decision by default may be rendered against the respondent in the event that the answer is not filed as required. Section 10.63, Service of Complaint, Service of Other Papers, Service of Evidence in Support of Complaint, and Filing of Papers. Service of complaint first. The complaint or a copy of the complaint must be served on the respondent by service, by certified or first-class mail, or by other service such as UPS or Federal Express. And service of papers other than by complaint, those can come by mail is fine, or either of the two others mentioned above. Service of papers on the IRS. Whenever a paper is required or permitted to be served on the IRS in connection with a proceeding, the letter should be serviced to the address designated in the complaint or at an address provided in a notice of appearance. But if no address has been provided in the complaint, then the address shown here is the address you should mail your response to. Service of evidence in support of complaint. Within 10 days of serving the complaint, copies of evidence in support of the complaint must be served on the respondent in any matter described in paragraphs 2 and 3 of this section. So what this is saying is if you've received notice from the IRS that you're under investigation and that there's a complaint being filed against you, they're required within 10 days to provide the evidence they have that they're going to be using against you in that complaint. Filing of papers. Wherever the filing of a paper is required or permitted in connection with a proceeding under this part, the original paper plus one additional copy must be filed with the administrative law judge at the address specified in the complaint. Answer and default. This is important stuff. Typically on the EA exam, there is a question about answering a complaint, and so this is a section you should pay close attention to. Firstly, filing. The respondent's answer must be filed with the administrative law judge and served on the Internal Revenue Service within the time specified in the complaint, unless on request or application of the respondent, the time is extended by the judge. Contents. The answer must be written and contain a statement of facts that constitute the respondent's grounds for defense. General denials are not permitted. The respondent must specifically admit or deny each allegation set forth in the complaint, except that the respondent may state that the respondent is without sufficient information to admit or deny a specific allegation. The respondent nevertheless may not deny a material allegation in the complaint that the respondent knows to be true, or state that the respondent is without sufficient information to form a belief when the respondent in fact possesses that required information, and the respondent must also state affirmatively any special matters of defense on which he or she is relying. Failure to deny an answer or allegation in the complaint. Every allegation in the complaint that is not denied in the answer is deemed admitted and will be considered proved. No further evidence in respect to such allegation need be adduced at the hearing. Default. Failure to file an answer within the time prescribed or within the time for an answer as extended by the administrative law judge constitutes an admission of the allegation of the complaint and a waiver of the hearing. So if you get the letter and ignore it, you're guilty. Signature. The answer must be signed by the respondent or the respondent's authorized representative and must include a statement directly above the signature acknowledging that the statements made in the answer are true and correct. So that concludes the ethics part of our class today, well, the Circular 230 part of today's class, with one last tidbit here, which is Subpart E, General Provisions. And it basically states that the IRS keeps a roster and makes that roster public. And the roster includes the names and statuses of enrolled agents, enrolled retirement plan agents, registered tax return preparers, and disqualified appraisers. It also contains a list of the qualified continuing education providers and also the names of providers for whom approval has been revoked. The next part of today's class, and we've got 10 minutes left, so there's no way I'm going to get through all of this. That's normal for me. But this information that's in the manual can be handy to you, especially if you are not already an enrolled agent, but you are considering becoming one. And it's got a great deal of information in it about how to become an enrolled agent and how to apply for the special enrollment exam. And I've even got in here the exam content. Now, whether you're an enrolled agent already, thinking of taking the enrolled agent exam, or have no interest in the exam at all, seeing the content of the exam can be quite illuminating, because the scope and the items that the IRS tests on is very broad and very specific as well. And so they delve into all of the different aspects of tax law covered in many, many different publications and tax forms. And you could expect to be tested on virtually every type of topic that is conceivable. And this is a list of all of the topics they test on, going through the next few pages, all the way until we get to page 69. And on page 69, once you've passed the C exam, the special enrollment exam, then you have to complete Form 23 to apply for enrollment to practice before the IRS, and you have to pay a fee. Next, we have some information in the manual about a power of attorney and who can have one. A power of attorney is essentially allowed only for a person who is authorized to practice before the IRS, or in certain cases, a person who has limited practice rights before the IRS. And if you are not qualified to receive a power of attorney, then you may be able to get a tax information authorization by filing Form 8821 instead. So a power of attorney authorizes you to represent an individual before the IRS with respect to the tax return, whether you prepared it or not. But if you are not an enrolled agent, attorney, or CPA, you are not allowed to have a power of attorney unless you prepared the tax return that is at issue. And if you need to get information from the IRS regarding a tax return or a taxpayer's documentation, you can do so without having a power of attorney by filing Form 8821. And 8821 and the power of attorney Form 2848 both do need to be signed by the taxpayer. In the case of a joint return, you need to have separate 8821s and separate 2848s for the taxpayer and the spouse. They cannot be joint. Centralized Authorization File, or CAF. Whenever you do file a power of attorney with the IRS for the first time, they will issue you a CAF, and you will use that CAF for all future power of attorney forms. And I did want to point out a comment here. Many times over the years, I've had people comment that an enrolled agent is able to represent clients in tax court, or that a CPA can represent taxpayers in tax court. I've heard the comment that the only difference between an enrolled agent and an unenrolled tax preparer is that they can represent clients in tax court. And that's not the case at all. An enrolled agent is authorized to practice before the IRS, and that means representing the clients before the IRS with respect to their tax return or an audit or an appeal. But tax court is an entirely different matter, and here's what the facts are on tax court. It is a common misconception that enrolled agents and CPAs have the authority to represent their clients in tax court. The reality is that anyone can be admitted to practice in tax court, whether they're an EA or a CPA or not. However, any individual admitted to practice must meet provisions described under Rule 200 of Title 20. And Rule 200 provides that an individual who wishes to represent his or her client in tax court must submit an application to the court that demonstrates the necessary qualifications. Further, non-attorney applicants must demonstrate the necessary qualifications by passing a written examination administered by the tax court. And if you want to know more about Rule 200, there's a link here that you can click on, or you can go to the URL here. So essentially, you may be an enrolled agent, you may be an attorney, and it may be to the point where your client needs to go to tax court, and that's where you end. You can't represent them in tax court. They're going to need to get an attorney, preferably a tax attorney, to represent them in tax court, unless you have met the rules described in Rule 200, which is that you've passed a tax court exam. And that's no easy animal to get through. And finally, I'm going to point out some of the other regulations that govern tax preparers. and leave you to peruse those in your own time after class has ended today. The first of these are Section 6107 and 6109. 6107 requires that the taxpayer furnish a copy of a tax return to the client at the time that the signature on that return is collected. And if you're electronically filing a return and you're collecting a signature on Form 8879, you need to furnish your client with a copy of the return prior to getting them to sign 8879 or at the same time they sign that 8879. A copy or list must be retained by the tax return preparer. Any person who is a tax return preparer with respect to a tax return or a claim for refund must retain a completed copy of the return or retain on a list the name and taxpayer identification number of the person for whom that return was prepared, and then they need to return that list over to the IRS if it's ever asked for. And moving on to identifying numbers, there's a whole bunch of provisions in here under the code about the requirement for issuing numbers, and really those are summarized in everyday language here in italics. When you file a tax return, you're required to put a number on it, and the IRS dictates what that number is, and you have to put it on there. Sometimes people refuse to give numbers, and there are provisions that can penalize a person for refusing to provide a number, and here is an example. If a tax return filer is required to report the identifying number of another person on his or her tax return, that other person is required to provide the number. For example, Sally must report the Social Security number or EIN of her child care provider on Form 2441. The child care provider is required by law to give that number and is subject to penalty if they refuse. Example number 2, Jane sells her home to Sam in a seller-financed mortgage. Jane and Sam must provide their Social Security numbers to one another. Jane will report Sam's SSN on her Schedule B as the recipient of interest from Sam, and Sam will report Jane's Social Security number on his Schedule A. And refusal by one or both of them to issue or provide each other with their numbers would be subjected to a penalty. Furnishing number of another person. The identifying numbers of other persons shall be included in all tax returns where required. For example, if you claim dependents on your return, you need to enter their numbers. And furnishing the identifying number of a tax return preparer, a tax return preparer must enter his or her identifying number onto all tax returns that he or she prepares. And we really are at the top of the hour, coming to the end of the class. And if you have any questions, you can go ahead and punch them into the chat forum, and I'll just kind of space things a little bit better here. Those of you who have questions are welcome to ask their questions. And I do see here, do we have to sign a client copy even if it is printed client copy on each page? No. You need to sign the tax return that is submitted to the IRS. I've never heard of a regulation that says you need to sign the copy that you give to your client. No. All right. So let's talk about some other civil penalties, because we've been reading all of the regulations and what they are, and that penalties do exist, but what exactly are the penalties? And there's lots of penalties that fall under all different kinds of sections, and it's conceivable that you could be penalized under multiple sections for the same offense because you would have been deemed to have made an offense under that particular section. So let's go through and see in summary what some of these are. Firstly, we have Section 6694, which has to do with understatement of a taxpayer's liability by a tax return preparer. If that's you, the penalty is an amount that is equal to the greater of $1,000 or 50% of the income derived by the tax return preparer with respect to the return or claim. So you've made a false return, you're being penalized. The penalty can be $1,000 or more than $1,000 if the fee you charged was, say, $3,000. They could collect half the fee you charged. And then they go on to describe what an unreasonable position is that would cause you to be subjected to this kind of penalty. And also contained in that section, but not written in there for you, is steps that the tax preparer can make to appeal penalties and procedures for abatement. If you want to know more, you'll just need to go to the code itself. Under 6695, there's a whole bunch of assessable penalties with respect to the preparation of tax returns, and they include failure to furnish a copy of the return. You're supposed to furnish the copy. You don't do it, $50 fine per return. If your firm has a policy of never furnishing copies, you could have 2,000 returns times $50, and it could go on for multiple years, but the maximum fine for any 1 year is $25,000. Failure to file a return. The law requires you to sign the return. If you fail to do so, it's $50 per return. And if you've got multiple returns over multiple years, that could add up. Failure to furnish the identifying number. $50 fine per return. Maximum fine in any year is $25,000. Failure to retain a copy or a list of the taxpayer clients for 3 years. It's a $50 fine per return, and a maximum fine in any year is $25,000. Failure to file correct information returns, $50 for each failure to file, and a maximum fine in any one period is $25,000. Negotiation of a check, endorsing or otherwise negotiating any refund check that is issued to a taxpayer. It's a $500 fine per check. However, the penalty does not apply to the deposit by a bank of the full amount of the check in the taxpayer's account in such bank for the benefit of the taxpayer. So essentially what it's saying is if a client asks you to deposit their tax refund check into their account, you can do that, but you're not allowed to endorse it. Separately, in the state of Oregon, there's a law here that says the taxpayer's check can't even be mailed to the office of the practitioner, so it should never touch our hands anyway. The closest I've ever come to dealing with that was many, many years ago. I had a client who had a refund anticipation loan. It came in, he was out of town, and he asked me to go and deposit that check in his bank account, which I did do for him. But in general, IRS wants you to stay away from your client's money. You shouldn't be cashing their checks. You shouldn't be endorsing their checks. $500 fine for each offense. And failure to be diligent in determining the eligibility for the earned income credit. You need to know the rules. You need to be diligent about EITC. And if you are not and you get caught, the fine is $500 for each failure. And that can add up in a hurry. Section 6701 penalties. This section imposes penalties of $1,000 on a person who knowingly submits a false return or other document to the IRS or aids and assists in the submission of a false or misleading claim. The penalty increases to $10,000 if the false submission relates to a corporation. And this is the code itself. I'm going to scroll by it. I gave you a summary of what it says. Section 7216, disclosure or use of information by preparers of returns. And this is where we get onto that Amway guy. Internal Revenue Code Section 7216 is a criminal provision enacted by U.S. Congress in 1971 that prohibits preparers of tax returns from knowingly or recklessly disclosing or using tax return information. A convicted preparer may be fined not more than $1,000 or imprisoned for not more than a year or both for each violation. The Secretary of Treasury is permitted to grant exceptions to this general prohibition by issuing regulations. And Treasury Regulation 7216 has been substantially unchanged for 30 years and did not address the modern return preparation marketplace, particularly e-file, preparation of refund anticipation loan products, and other commercial products and services during the return preparation process. So after a long process that included many public suggestions and comments, updated regulations were published on January 7 and again on July 2 of 2008. There's links here to read those if you are interested. And essentially what these use rules are getting at is that you come into contact with tax preparer information and you need to use it for the purpose that it was intended, which is preparation of that client's tax return. If you use it for a purpose other than preparation of the tax return, then you're probably out of scope of the law. You're probably in violation of the law. And the only exception to that really is if you're ordered to use the information for another purpose by the federal government or the client authorizes it. So for example, when you're preparing a tax return and your client wants to do a bank product, the refund anticipation loan product is of course dead, but we still have the refund anticipation check products where a client may have their fees withheld from their refund and have the check delivered to the tax practitioner's office. And if you're using software to generate that, the software program we use, Drake Software, certainly prints out a use form, an authorization to use form with this code 7216 written on it. The specific purpose of that form is to authorize the use of that taxpayer's information in the application process to work with the bank. And then there's another provision where the bank has the client sign off on the ability of the bank to even use the information contained in the tax return to create an account and set up an account for that client. So it's very specific information in here about how and when a tax practitioner can use client information. And it also extends on to other areas like the electronic transmitter, the software developer, and so forth. And moving on down, after we get through all of that, we come to Safeguarding of Taxpayer Information. In its enrolled agent exam and also in the RTRP exam, the IRS specifically states that they ask questions from this particular trifold brochure, IRS publication 4600. It has to do with privacy and security rules. These are not Internal Revenue Code rules, really, although some of them are. There are federal rules under the Graham-Leach-Biley Act and other acts that require protection and safeguarding measures be in place to ensure that taxpayer information is not stolen or misused. And you should read through this brochure to see whether or not your firm and your own personal conduct is appropriate for safeguarding. And among the provisions listed or described in here is that you should maintain a list of all locations where you handle taxpayer information. You should assess the risk of unauthorized access, use, disclosure, modification, destruction of taxpayer information that you handle. You should assess the impact of unauthorized access, use, disclosure, modification, or destruction of taxpayer information that you handle. You should write and follow an information security plan that shows how you are addressing risks, and there are examples of information security plans on the Internet. Also specify in contracts with service providers the safeguards they must follow and monitor how contractors handle taxpayer information. You should test, monitor, and revise your information security plan on a regular basis. You should put in place additional safeguards as needed. You should provide your clients with privacy notices because you're required to do so under the law, and you should follow your federal, state, and local laws and regulations. Information security rules require businesses and individuals to use safeguards to protect taxpayer information from events that can result in unauthorized use, identity theft, fraud, or destruction of information. The safeguards that businesses and individuals put in practice should be appropriate for the size, complexity, nature, and scope of their business activities. We have the e-file mandate. I'm not going to read that to you. It should be pretty common knowledge now that you are required to e-file your client's returns if you or your firm do more than 11 in a year. And so I have information in here about how to apply for an EFIN. And there's also information in here on denial of an EFIN, what would cause an EFIN to be denied. And among those, of course, are disreputable conduct. So even though the IRS is currently not able to enforce the RTRP test or the continuing education requirements for the test, the business itself must still have an EFIN and must still be in compliance with all these ethics requirements. And if the IRS comes along and strips the business of its EFIN, it's essentially shut down and out of business anyway. So the EFIN is another way of regulating the firms. IRS has a publication called 3112, which is the IRS E-File Handbook. And if you are applying for an EFIN, you need to get into that publication and read it. It provides all of the instructions on how to apply for an EFIN and how the EFIN process works. It also contains information on safeguarding the IRS E-File system, provider rules and responsibility. It has information for not-for-profit providers, testing, advertising standards, monitoring of authorized e-file providers, revocation of the e-file provider authority, sanctioning levels of infraction, and also administrative review. I see a question here. An RTRP can prepare corporate returns or only enrolled agent can do that? Actually, an RTRP can prepare any tax return at this point. The IRS has not restricted that in any way. The restriction was really rather that if you wanted to prepare 1040 returns, you had to be an RTRP, but there's no restriction on who can prepare corporate returns at this time, except, of course, you have to have a PTIN. How many returns should I be exposed to before attempting to take the EA exam? The EA exam is not an easy test, but I've seen people pass the EA exam never having prepared a professional return at all. Our tax school, our basic tax course is so thorough. We do have people who take our basic tax course and then move on past the Oregon exam, and while they're at it, head on into the EA exam. So I would say it's a combination. You know, experience is going to get you to a certain point, but if you've got lots of experience doing everything wrong, experience can often be a bad thing. So I think it's really important to take really good education. Our own school, we don't have per se an EA course. I keep talking about how we'll get there eventually, but I would say 90% of the EA exam is covered in the courses that we currently offer. If you took every course we offered, what we don't cover is maybe 10% of the exam, and we are working on filling that gap so that we can officially say we have an EA prep course sometime in the near future. I never have time to quite pull that off. I've been promising it for years, but maybe this year will be the year. At any rate, taking that test, I would advise strongly that you take a really good course. And of course, I think our course is one of the courses you should take. And then aside from that experience, I would really look at who you're working under, the quality of the people you're working under, and when you're ready to try it, you're ready to try it. The worst thing that'll happen is you'll take it and you'll fail and you'll expose your weaknesses. And I certainly have just provided you with a list of all of the topics covered in the EA exam. And on the IRS website, under the EA category for tax professionals, if you search enough, you will actually get to a point where they have prior year enrolled agent exams and the answer keys to those. And you can kind of see the types of questions they're answering.
And by now, you should have completed your attempt of the final session of the basic tax course in terms of the quiz, and that is, of course, the quiz covering IRS ethics rules. Now, if you are a tax preparer working in Oregon, California, or Maryland, there's probably some additional ethics rules that you should be aware of, but don't let what you understand about local state ethics interfere with your understanding of IRS ethics, because of course this quiz and session 23 in its entirety focuses solely on IRS ethics. And by that same token, if you are a CPA working in any state, your Board of Accountancy is going to certainly have ethics requirements for you as you operate as a CPA in your state. But again, those ethics rules are separate and apart from IRS ethics, which is what was covered in today's class. Moving on to the most frequently missed questions from today's quiz. The first question in line is question number 5. How long must each practitioner maintain records of their completed CPE credits? And the correct answer is C. CPE credit information must be retained for a period of 4 years following the date of the renewal of enrollment. And if we take a look at where you go inside IRS Treasury Circular 320, the answer is found in section 10.6H1, where it specifically says you must retain for a period of 4 years following the date of renewal. Moving on to question number 8. Of the following statements, which one is not considered to be practiced before the Internal Revenue Service? Essentially, what IRS is getting at when it refers to practice, it's referring to a level at which the practitioner must have a PTIN and must either be a CPA, an attorney, an enrolled agent, or a registered tax return preparer. Now, as I'm teaching this class, we do know that the registered tax return requirements are in limbo, and it is possible that this particular rule will change if the IRS loses in appeal. In other words, in appeal, it may be determined or basically established that the IRS cannot consider a person to be practicing for preparation of a tax return. But currently, as we sit, Circular 320 does state that practice before the IRS does include preparation of a tax return. And you can see D says preparing a tax return is practice. And so the correct answer is a search for the one form of work on behalf of a client that would not be considered practice before the IRS. So let's take a look here. Communicating with the Internal Revenue Service for a taxpayer regarding that taxpayer's rights, privileges, or liabilities under the laws and regulations administered by the IRS. This is practice, so it is not a correct answer to the question, which is, what is not practice? B, representing a taxpayer at conferences, hearings, or meetings with the IRS. That also is practice. And of course, preparing a tax return, option number D, is practice. C, furnishing information at the request of the IRS. This is not practice, and that's clearly spelled out in the IRS rules. Refer to section 10.8B. Question number 11. Sarah Birch became an enrolled agent on March 12, 2005. Sarah is ordering business cards and advertising for her accounting and tax practice. Of the following presentations listed below, which one will violate Circular 230 rules for advertising? And the first one in line is the one that's a problem. Sarah Birch, enrolled agent, certified to practice before the IRS. Circular 230 goes out of its way to specifically state that you may not use the word certified as a tax practitioner to describe your function.
And whether you're a registered tax return preparer or an enrolled agent, both of those two designations are prohibited from using the word certified to describe their relationship with the IRS. Certified is essentially reserved for CPAs, certified public accountants, who are the only people who are allowed to use the word certified in their title. Certainly, Sarah can use enrolled agent, representing taxpayers before the IRS, or enrolled to represent taxpayers before the IRS, or admitted to represent taxpayers before the IRS. So B, C, and D are all acceptable terms that she can use on her business card. A is the word certified is one she may not use. And finally, question number 20, Matt, an enrolled agent, provided tax advice to XYZ Corporation on a federal tax matter. The Securities and Exchange Commission, or SEC, is reviewing the required filing of XYZ Corporation and asks to see a copy of Matt's tax advice. The tax advice is not protected by federally authorized tax practitioner privilege under IRS Section 7525 from disclosure to the SEC because, and it's your job to figure it out, Matt is not a lawyer, so it's not relevant. B, Matt is not a CPA. This is false. It's not relevant. In other words, is this the reason why he's not protected? He's not a lawyer. No, that's not the reason it's not protected. He's not a CPA. No, that's not the reason it's not protected. C, the federally authorized tax practitioner privilege does exist, but it protects advice only against disclosure to the IRS and not other government agencies. That is the true statement. And finally, D, the federally authorized tax practitioner privilege protects only advice to individuals. That too is false. So you can read here Section 7525, confidentiality privileges relating to taxpayer communications may only be asserted in any non-criminal tax matter before the IRS and any non-criminal tax proceeding in federal court brought by or against the United States. So essentially, SEC is not the Internal Revenue Service, which is why the information is not protected. All right, that concludes this review of the Session 23 quiz answer key. At this point, you have essentially finished the federal portion of the basic tax course. If you are a federal-only student, it's time to start working on Kris Kringle and preparing to take your closed book final and your open book final exams. For those of you who are moving on to study California and Oregon law, you've got a few more sessions to go. And so those of you who are California and Oregon students, you do need to move on with completing other aspects of this course. But federal-only students, it is now time to take your final exams. Thank you for participating in the basic tax course. We hope you've had a terrific educational experience, and we hope to see you in some of our CPE programs in the future. Thanks so much, and bye-bye. Finch, F-I-N-C-H, Finch.